Thank you. Well, good morning.
Good morning, Your Honor.
Good morning, Your Honor.
We're not starting just yet. Just wanted to see, how are y'all doing this morning?
I'm good. How are you?
Good, good. Did y'all get some good sleep last night?
As best as I could.
I remember what that's like for sure.
Yeah. Did you judge yesterday, or is this your first day doing so?
I judged yesterday. I can't speak for the other judges, but I'm a law student at Baylor Law School, second year. And we all, I'm sure, did mock trial back in the day. So we're pretty familiar with all this, but best of
Asher, I don't think you were able to, this is Joe Previty. I don't think you were able to tell them that you're at Baylor Law School.
Okay.
It doesn't matter. This round is good to begin.
All right.
Okay, never mind then.
Your Honor, is it actually possible we could get permission to record?
Absolute. Well, actually, Elliot, are you still here? I think he just dipped, but I know that the judges were asked expressly not to record, and this is being streamed on YouTube. So is it possible that you could access the YouTube recording that way?
We'll try that out. Thank you so much.
Is that okay?
Yeah, we'll try that out. Thank you.
Okay. All right. So if we have the all clear to begin, let's just go ahead. Let's call to order the estates of Genesis Petrillo versus Peony Estates and Harper Martini. My name is Judge Asher Miller. The scoring judges, by the way, would the scoring judges just flash on screen? Just give me a thumbs up. Let me know y'all are ready to begin. Okay, wonderful. That is good to know. All right, and for those who are watching, we're going to begin with opening statements. So please put your camera into speaker view. And also at this time, try to go over to the video settings and make sure that you set it at hide all non-video participants. That way we can make sure that our attention is on the speaker. Let's see, what else did they need me to say? And yes, at this time, let's make sure that the attorneys make their appearances. And also, would it be okay? Let's have the witnesses make a brief appearance as well. Please just state your first and last name so that we don't have any mispronunciations later. So beginning with the plaintiff.
Good morning, Your Honor. May we begin with appearances? My name is Ruth Kim, and I, along with my co-counsel Daniel Chung
Good morning, Your Honor.
and Chris Babineau,
Good morning, Your Honor.
represent the plaintiff in today's case, Joey Petrillo, as administrator of the estate of Genesis Petrillo, pursuing the cause of action of civil battery.
Wonderful. And witnesses, please.
Good morning, Your Honor. My name is Angel Rodriguez.
Good morning, Your Honor. My name is Sam Arnold.
Good morning, Your Honor. My name is Dr. Kwan.
Wonderful. The defense, please make your appearances.
Good morning, Your Honor. My name is Alexis Pineda, and these are my co-counsel, Heather Worth.
Good morning, Your Honor.
And Ava Singh.
Good morning, Your Honor.
We represent Harper Martini in today's case, and we'll be representing the defense.
All right, and the defense's witnesses, just state your witness names.
Good morning, Your Honor. My name is Harper Martini.
Good morning, Your Honor. My name is Dr. Richard Cannon.
Good morning, Your Honor. My name's Austin Lewis.
All right, wonderful. Okay, so for all who are not the attorneys who will be giving opening statements, please turn off your video. And we will now hear opening statements from both parties. Actually, are there any housekeeping matters that either of the attorneys would like to address?
Yes, Your Honor. Before we begin, we have a few pre-trial matters that we would like to address.
Hmm.
First, we would like to invoke Rule 615, which constructively sequesters witnesses.
The witnesses may be sequestered.
May we assume that all witnesses have been sworn in prior to their testimony pursuant to Rule 603?
Yes, ma'am. Absolutely.
What are your honor's preferences regarding asking permission to share our screen for evidentiary purposes?
I found last round it was a bit tedious every time we went through that. So we're going to go ahead and just make the request, and I'll say, please proceed.
Yes, Your Honor. Your Honor, do we have permission to screen share rules of evidence, case law, stipulations, special instructions, and other documents regarding the case at hand when attorneys are addressing them?
Yes, that's strongly encouraged. Great.
Are we free to move around during our statements and our examinations?
Well, being on Zoom, it's a little different, but limited. Obviously, nothing overly distracting. But you may, for sure, during opening statements, stand up. Small movements are fine.
Yes, Your Honor. May we assume that all evidentiary arguments are heard out of the earshot of the jury?
Yes, you may.
And may we assume that anything being screen shared is not published to the jury until it has been entered into evidence?
Yes.
Finally, we would like to remind the court that exhibits 1 through 10 are pre-admitted per stipulation 3.
Very good. I will take note of that, and thank you.
With that, the plaintiff is ready to proceed.
Wonderful. Defense?
Yes, Your Honor. For the purposes of Rule 615, Harper Martini will be remaining in trial as our party representative.
That's fine. Absolutely. Obviously, being Miss Martini, that's fine.
Yes, Your Honor. And you mentioned you would like us to request when screen sharing exhibits. Does that apply to exhibits that are already in evidence, or may we share those freely since they're already on the record?
You certainly will be allowed to share them. Just make sure to request, Your Honor, at this time, may I go ahead and bring up exhibit so-and-so, even if it's already been admitted, just to let me know what we're about to see.
Yes, Your Honor. With that, the defense is ready for trial.
Excellent. And also, I would like to make it known to both counsels that we will not need to have any requests to approach. This is all supposedly a constructive sidebar in engagements with the court. Additionally, if an objection is sustained, there's no need to request that the previous testimony be stricken from the record. That's superfluous. We don't need to do that. But that's all that I have. If that is all the housekeeping matters that we'll need, plaintiff, you may begin at any time you're convenient. You're ready with your opening arguments.
May I proceed, Your Honor?
Yes, you may.
Your Honor, opposing counsel, members of the jury, may it please the court. Planned to poison Petrillo. Ladies and gentlemen of the jury, I want you to pay attention to those words, because throughout today's case, you're going to hear about how the defendant planned to poison Genesis Petrillo. Now, this is Genesis Petrillo. He was about to be a married man. But on the morning of what was supposed to be the best day of his life, the morning where he was supposed to marry his soulmate, Mr. Petrillo tragically passed away. Now, the question is, why did Mr. Petrillo die? Now, the evidence you will hear throughout today's case will show that Mr. Petrillo died of pesticide poisoning, and that those pesticides came from a wine bottle, and that wine bottle came from the defendant, Harper Martini. And the evidence will show that Harper Martini poisoned Genesis. And it is for those reasons that we, the plaintiff, are suing the defense for battery. Now, there are 3 elements to battery. First is an act by the defendant. The second is that the defendant intends to cause physical or bodily harm to the defendant. And the third is that the harmful or offensive contact was received by the defendant. Now we have to prove all three elements to you, and we have a burden of proof of showing this by a preponderance of the evidence. Now, in order to help you understand this burden, I want you to imagine the scales of justice. And on one side is the plaintiff's case, on the other is the defense's case. And both sides will put their evidence and their testimony on their scale in order to prove their case. And what we as the plaintiff must do to show is to prove our case by 50% and a grain of salt. If we tip the scales by just a grain of salt of evidence, then we as the plaintiff have met our burden. Now, proving this burden isn't going to be easy, but we as the plaintiff embrace this burden because we will prove it. We will show you how the defendant planned to poison Petrillo. And we're going to do this by calling three witnesses. The first is the best friend of Mr. Petrillo, Angel Rodriguez. And this friend is going to testify to the contentious relationship between the defendant and the victim. This witness is also going to testify to how the victim feared for his life when it came to the defendant. Now, the second witness we're going to call is a wedding caterer, Sam Arnold. And this wedding caterer was involved with Mr. Petrillo's wedding. And this caterer is going to testify once again to the toxic relationship between the defendant and the victim. Most importantly, he's going to testify to how the defendant formulated a plan to poison Petrillo. Finally, you're going to hear from the physician who treated Mr. Petrillo prior to his death, Dr. Kwan. And this doctor is going to talk to you about how Mr. Petrillo was most likely poisoned by pesticides, and how those pesticides came from a wine bottle, the same wine bottle that that the defendant gave to the victim. Now, at the conclusion of today's trial, my co-counsel, Mr. Babineau, is going to come up here and talk to you about the evidence, about the elements, about how the defendant planned to poison Petrillo. And we expect that the only reasonable conclusion that you'll be able to find is that the defendant committed battery. We expect that you will find the defendant liable. Thank you.
Thank you, counsel. Defense, would you like to give your opening arguments?
Yes, Your Honor.
All right, you may begin.
May it please the court. Not every story has a villain. Members of the jury, I want you to think about every story you've ever been told. I want you to think about the characters, the plot, the conflict. And I want you to notice that almost every one of these stories has a bad guy, a villain. But the thing is, these stories are just that, stories. They're works of fiction. And today's case is the truth. There's no cartoon characters or convenient plot twists, and there definitely isn't an evil mother-in-law trying to kill the groom. The reality is that on June 8th, 2019, Genesis Petrillo died, and his death was a tragedy. But it's the truth. Don't let the plaintiff create a work of fiction out of today's case and unnecessarily make a villain out of Harper Martini. Now, Harper Martini is a name you'll hear throughout today's case. You'll hear that Harper Martini is a successful businesswoman who worked her way up to being the owner of the #1 winery right here in Midlands. You'll hear that Miss Martini would have done anything for her daughter, Casey Soto. Members of the jury, you'll also hear that back when business wasn't doing so well at Miss Martini's winery, Peony Estates, the company was forced to switch to a cheaper and less safe chemical pesticide. A chemical pesticide that its employees were unable to safely handle. You'll hear that these unsafe practices could have led to the wine that Genesis Petrillo drank to be contaminated. The truth is that on June 7th, 2019, Genesis Petrillo drank contaminated Cara wine from the winery. And the very next morning, he passed away. On what was supposed to be the happiest day of his life, his wedding day. The truth is that today's case is an accident. There's no villain. Now, members of the jury, today you're going to hear from Austin Lewis, the head winemaker at the winery. And he'll tell you that company oversights could have caused that 2019 Cara wine that Genesis Petrillo drank to be contaminated. You'll hear that that same 2019 Cara wine was sealed right after it was made, meaning that there was no opportunity to contaminate that wine after it was sealed and before it was given to Genesis Petrillo. Today, the plaintiff is pursuing a claim of battery against the defendant, Harper Martini. They have to prove to you, by a preponderance of the evidence, that Harper Martini committed an act of battery. They have to prove to you that this is more likely than not, meaning that this is the most likely explanation for Genesis Petrillo's death. So let's break down what that means. First, the plaintiff must prove an act by Miss Martini. Second, the plaintiff must prove that Miss Martini intended to cause harm. And third, the plaintiff must prove that she did cause that intended harm. Members of the jury, it's not enough to portray Miss Martini as a villain. The plaintiff has to prove it as well. And we expect that they won't be able to do that. Genesis Petrillo lost his life due to a tragic accident. At the end of today's trial, we'll ask you to make sure that Harper Martini doesn't lose her life because of something she didn't do. At the end of today's trial, we'll ask you to find Harper Martini not liable. Because not every story has a villain. Thank you.
Thank you, counsel. All right, so if we're ready to begin, let's go ahead and have the plaintiff call its first witness. Please proceed.
Yes, Your Honor, the plaintiff calls Angel Rodriguez to the stand.
All right. And at this time, would everyone please change their view to gallery view so that we can have all of the relevant persons on screen. All right. Ms. Rodriguez, you've been sworn in. You are under oath. You may begin.
Ms. Rodriguez, please introduce yourself to the court.
My name is Angel Rodriguez.
And what do you do for a living?
I'm a kindergarten teacher down at our elementary school.
So why are you here today?
I'm here to talk about Genesis, about his death, his wedding, and everything I saw that night.
All right, now you mentioned Genesis. Would you recognize a picture of him if I were to show it to you today in court?
I would.
Your Honor, permission to publish to the jury what's been pre-admitted into evidence as Exhibit 1.
Apologize. Yes.
Now, do you recognize this, Ms. Rodriguez?
I do. That's Genesis.
And he looks on or about the same as you've seen him in the past?
Exactly the same.
And Ms. Rodriguez, who is Genesis to you?
Genesis was just the most amazing person I've ever met. I got to know him one summer and he just lit up the whole room.
Now, you mentioned Genesis was getting married. Who was he getting married to?
Casey Soto.
And what can you tell us about Casey Soto?
Casey, I mean, we all knew each other, but at the end of the day, Genesis belonged with Casey, and they were supposed to get married at this winery, some place that Casey's mom owned or something, Peony Estates.
Now, Ms. Rodriguez, what can you tell us about Casey's mom, the defendant, in today's case?
She looked like she always wanted to pick a fight with Genesis. I mean, she was really proud of her winery and everything, and I never really liked her.
Now, Ms. Rodriguez, what, if any, interaction did you have in the wedding planning?
I hesitated a bit, but I was part of the planning process. Everything seemed to be going fine, but the more that Harper got involved, the more conflict and drama there was. It just became a mess.
All right, now, Ms. Rodriguez, I'd like to move forward to June 7th, 2019. What, if anything, was supposed to happen on that day?
That was the day of the wedding rehearsal. Everyone got together to have dinner afterwards.
And what, if anything, happened that night before the dinner started?
Harper tried to pick a fight with Genesis again. I mean, they told Genesis that they should just leave and save this family the headache. Otherwise, I will make you disappear. When I heard that, I just got so scared.
Objection, Your Honor. Under Rule 701, the witness just said that Harper Martini tried to pick a fight. This is an opinion testimony by a lay witness that is inadmissible in today's case.
Response?
Your Honor, as per Rule 702, this witness is testifying to her rationally based perception about what she saw that night. And from what she saw, the defendant picked a fight with Genesis.
I'll overrule the objection. She can make testimony as to her present sense impression, what she reasonably saw as a lay witness.
Yes, Your Honor. Now, Ms. Rodriguez, what, if anything, happened after the defendant said those things to Genesis?
After they said that, I got really nervous. Harper just grabbed Genesis by the arm and yanked him into the hallway.
Now, do you know what happened in that hallway?
Your Honor, under Rule 404, this is improper character evidence, specifically to the fact that Harper Martini yanked Genesis and put him into the hallway. This is using past instances of different conduct to show of violence specifically to show that on the day in question, Harper Martini was violent.
Response?
Your Honor, as to Rule 404, we're not using this to show conformity therewith. We are using this testimony to show intent, and we're also using it to show motive. This testimony could also be used for a lack of accident under Rule 404B2. Okay.
I will again overrule the objection. It's true that motive is probative. However, I now am beginning to see it's not necessary to bring up the rules of procedure for whoever is doing that. If there is a serious conflict that I'm not able to resolve on the cuff, we may resort to that. But for now, we can just have objection verbally without reference to it. All right, overruled. Continue.
All right, now, Mr. Rodriguez, I'll ask that question again. What, if anything, happened after the defendant yanked Genesis into that hallway?
I wasn't 100% sure what happened after that, but I went to ask Genesis about it. He told me that he was afraid Harper was going to kill him if he wasn't careful. He wasn't laughing at all. He looked so serious to me.
Objection, Your Honor, to hearsay, to Genesis Petrio's statements that he was afraid that Harper Martini was going to kill him.
Response.
Yes, Your Honor. The statement elicited by Mr. Petrio was that he was afraid. That, Your Honor, is under Rule 803, is a then existing state of mind.
Response, Your Honor.
Yes.
The statement elicited was that Genesis Petrio was afraid that Harper Martini was going to kill him. That statement is being used for the truth of the matter asserted that Harper Martini was trying to kill Genesis Petrio, which is why it's inadmissible in today's case.
All right, sustained. Please continue.
All right, now, Ms. Rodriguez, what, if anything, happened after that interaction but before the dinner?
I saw Harper. She was going towards the kitchen and she had this canister that said pesticides on it.
And what, if anything, happened when you saw the defendant with a canister that said pesticides?
I went up to talk to her, and Harper said, "It's for pests, like Genesis." And I thought it was really weird, but I just went to the dinner and now I wish I stopped her or something.
All right, now, Miss Rodriguez, what, if anything, happened in the dinner itself?
Harper kept calling Genesis a problem child, and then Harper tried to give us all these party favors, bottles of wine, but Genesis got this different bottle that no one else got. It was Cara or something. She said it was special.
And would you recognize that Cara wine if I were to show it to you today in court?
I would.
Your Honor, permission to tender and publish what's been pre-admitted as Exhibits 2A and 2B.
Yes.
Ms. Rodriguez, do you recognize this?
Yes, I do.
Has it been changed or modified in any way?
No.
Is it a fair and accurate depiction of that Cara wine as you saw it that night?
Yes.
All right, now, what, if anything, happened after the defendant gave Genesis this Cara wine?
After that, Genesis drank several glasses. I even sipped a little bit, but it just was wrong, so I spit it right back out.
And from what you saw, how was Genesis acting after he had this Cara wine?
It was so weird. They were slurring and they couldn't move right. It looked like something was wrong. Genesis even told me, "This isn't a feeling that I felt before." And
Objection.
I should have taken it more seriously.
What was your objection, defense?
To hearsay to Genesis Petrio's statement.
Response.
Your Honor, again, under Rule 8033, a then existing mental, emotional, or physical condition, this is Mr. Petrio's statement of how he was feeling physically, that he didn't feel, that he never felt anything like this before.
Response.
Your Honor, the statement specifically was that I haven't felt this way before. That doesn't fall under Rule 8033 because it's not a physical condition. A physical condition would be something like saying, "I'm sick," or "I don't feel good." And because of that, this is inadmissible.
I will sustain the hearsay objection. Please continue.
Yes, Your Honor. Now, after you saw that Genesis didn't look okay, what, if anything, did you do?
We were sitting down for a while and he was slumped over and I couldn't even smell any alcohol on his breath, which was really weird. So I took him up to his room.
And what, if anything, happened when you got to Genesis's room?
That's when I started to panic. Genesis was just throwing up everywhere. He was sweating and he said one last thing to me before he passed out. He told me to call 911. So that's what I did. And I rode with him in the ambulance all the way to the hospital.
And what, if anything, happened when you got to the hospital?
I stayed by his side all night. And around 8 a.m. in the morning, the doctors told me that Genesis was in a coma. And that's when I knew that I should probably call his fiance. She's the one that should be here, not me. So I tried to get back to the winery, to Peony Estates.
And what, if anything, happened when you got back to the Peony Estates?
Before I could even do much, I ran into Harper again, and she told me, I couldn't even say anything, and she told me Genesis got poisoned. Oh no, we'll have to cancel the wedding. And right after that, I went to go tell Casey, his fiance.
And what, if anything, happened when you told Casey?
She looked so beautiful. I mean, she was in the white dress and everything. Honestly, I thought I would have been the one wearing it. So it hurt me to have to tell her that Genesis was in the hospital. We rushed back right after, but we were too late.
Ms. Rodriguez, what do you mean you were too late?
We got there 5 minutes after Genesis had died.
And to your knowledge, how did Genesis die?
I learned that Genesis had died from poisoned wine.
At this time, we passed the witness.
Thank you. I've been informed. We're going to make sure that the scoring judges are ready before we move on to cross exams. So just give me that thumbs up and we can proceed. Mr. Swallows is good.
Good to go.
Excellent. All right, defense, would you like to proceed with cross?
Yes, Your
All right, you may begin.
Now, Ms. Rodriguez, I just want to get a few things clear for the jury. Today, you're testifying on behalf of the plaintiff, right?
I mean, if that's what you call it, yeah. I just want justice for Genesis.
You know that today the plaintiff is trying to show that Harper Martini poisoned Genesis Petrillo.
Objection, Your Honor,
That's what
calls
I
for
believe.
legal knowledge. This would ask my witness to speculate as to what we as the plaintiff want.
Response.
Your Honor, this isn't speculation. Today, Ms. Rodriguez is voluntarily testifying on behalf of the plaintiff. She's supposed to know about some of the basic information that the plaintiff is pursuing in today's case.
I will sustain the objection. Please try to keep questions for Ms. Rodriguez limited to her knowledge as a lay witness and not a legal person.
Yes.
Yes, Your Honor.
Now, Ms. Rodriguez, you were a member of the wedding party for Genesis Petrillo and Casey Soto's wedding, right?
I was, but not in the role I thought I would be.
Exactly. You were a part of the wedding party, but you were more involved in going to events, right?
I mean, I just offered help whenever Genesis and Casey asked for it, yeah.
That means that you were at bachelorette parties.
Yeah,
You were at the wedding rehearsal,
yeah,
and you would have been at the wedding, right?
I would have, yes.
And throughout that entire time, you never once saw Miss Martini try to poison a bottle of wine.
I wasn't with her the whole time. I don't know what she was doing.
You never saw Miss Martini try and hurt Genesis Petrillo in any way, right?
She did, though. She grabbed Genesis's arm and just yanked him in the hallway. It looked like it would have hurt.
Actually, Miss Rodriguez, she just pulled him into the hallway. Isn't that correct?
If you were there, you would have seen she yanked him hard.
Has it always been your testimony that she yanked him, Miss Rodriguez?
I mean, that's what I saw.
Are you sure you don't mean that Miss Martini pulled Genesis Petrillo into the hallway?
I mean, pulled, yanked. All I knew was I was scared.
Exactly, Miss Rodriguez. You never saw Miss Martini hit Genesis Petrillo?
No, I didn't see that.
You never saw her shove Genesis Petrillo?
Objection, Your Honor, confusing the issues. May I be heard?
Yes.
The opposing counsel has been asking my witness if Miss Martini did any kind of physical bodily harm, hitting her, pushing her, anything like that. And that's simply what today's case is not about. It's confusing the issues with the jury, making them think that this battery may have something to do with a physical contact, where in today's case, we are alleging that the defendant poisoned Mr. Petrillo.
Response, Your Honor. The plaintiff brought this up during their direct. They opened the door for this line of testimony when they talked about Miss Martini yanking Genesis Petrillo into the hallway.
I will overrule the objection. However, make sure that this goes somewhere and not just repetitive on this one point.
Yes, Your Honor.
Yes, Your Honor.
Now, Ms. Rodriguez, just to clarify, you never saw Miss Martini try and hurt Genesis Petrillo in any way, right?
Not physically.
Now, I want to move on from this and talk about something that you said on direct. You said that Miss Martini was holding some pesticide and she said it was for pests like Genesis, right?
Objection, compound. Maybe here.
Response. Actually, please elaborate a little bit more on your objection, counsel.
Yes, Your Honor. Ms. Singh is asking whether Miss Martini, both one, had the pesticides, and the second part of her question was, and she did something else with those pesticides. So that's a compound question, Your Honor.
Response, Your Honor.
Yes.
We're just repeating a quote that was elicited on direct examination.
And I'll overrule it. That question was already asked and answered on direct, so it's not necessarily two completely novel questions. So please continue.
Yes, Your Honor.
Now, just to clarify, Ms. Rodriguez, Ms. Martini said that this was for pests like Genesis, right?
She did, and I can't believe she really used it.
Ms. Rodriguez, you want the jury to believe that Harper Martini confessed her entire plan to you like some cartoon villain?
Objection, Your Honor, calls for speculation. This witness is not supposed to know exactly what the jury would think. That would be something that maybe a legal analyst or maybe a psychiatric evaluator might know, but not this late.
Right, and that's related to your previous objection, which I sustained. I'll sustain it again. Counsel, you'll have opportunity on closing arguments to make legal conclusions based off of witness's testimony. Please continue.
Yes, Your Honor.
Yes, Your Honor.
Ms. Rodriguez, something that you left out of your direct is that after Ms. Martini said this to you, she actually just said she was joking, right?
That's what she said, but I guess she wasn't.
You don't know if the winery accidentally contaminated the Cairo wine.
I don't know what happened. All I know is that Harper had this can and then she went into the kitchen. And that's where the wine was.
Now, Ms. Rodriguez, I want to talk about why you might be testifying the way you are. You and the victim were close, right?
We were.
You were best friends.
Yes.
In fact, you thought that you would be the one in the wedding dress. Isn't that correct?
I did, but I just wanted him to be happy.
You dedicated yourself to this case.
Yes.
You've talked to justice activists, right?
Yes, I want the truth to come out. I want them to know what Harper did and that it's wrong.
Exactly, Ms. Rodriguez. You want Harper Martini to pay.
No, I just want the truth to come out.
Thank you, Ms. Rodriguez. No further questions.
No, Your Honor. May this witness step down?
Please, Ms. Rodriguez, you may be excused. Again, I think just for making it a little easier in the future, just thumbs up from both the scoring judges in between each round. All right, good. That's one. And that's two. All right. Plaintiff, please call your second witness.
Yes, Your Honor. The plaintiff calls Sam Arnold to the stand.
Mr. Arnold, you are under oath. Plaintiff, you may begin your questioning when you would like to begin.
Yes, Your Honor. Mr. Arnold, could you please state your name for the court?
My name is Sam Arnold.
What do you do for a living?
Well, I'm a karaoke singer at night and I have a bar, but I actually am a food service provider here at Midlands.
Could you tell the court why you're here today?
Well, I'm here today because I refused service to Celine Dion. No, that's not right. Oh, I see. Harper Martini's here. Well, I think it's because I serviced the wedding rehearsal for her and I was supposed to service the wedding day.
Mr. Arnold, how do you know the defendant?
Well, I met her in 2016. We were both celebrating our first year anniversary and she hired me to cater for her party. And that's when we built this business relationship.
And how long have you been working with the defendant?
Well, up until Genesis' wedding. So from 2016 till 2019.
Mr. Arnold, could you describe how you know the victim in today's case?
Well, my first meeting with Harper Martini exclusively talked about Genesis Petrillo, and I felt I knew so much about her. And then I even met her met Genesis a few times. And I'm sorry, can you repeat the question? I'm a little nervous. It's my first time in court.
Yes, Mr. Arnold, could you explain why you felt you knew Mr. Petrillo so well?
Because my first meeting with Harper after she told me that her daughter was going to get married was exclusively about Genesis, and I could not understand why. It was so weird to me. And I was getting ready to leave, but Harper told me something. I mean, Harper said something to me that really stuck out, and it was very curious. She slammed the bowl on the counter and she yelled, "Anyone but Genesis," literally anyone. And after that, it just stuck. I knew Genesis.
Now, Mr. Arnold, you mentioned that you were involved in the rehearsal dinner. How did that day start out for you?
So the day of the wedding rehearsal dinner, it was June 7th, 2019. I arrived at 11 a.m. and I found the kitchen to be a bit unorganized and very chaotic. It was very strange. And I was able to ascertain that Harper asked the kitchen staff to leave so she could work on finalizing gifts for the wedding guests.
Did you notice anything else in the kitchen?
Yeah, so after I met with Harper and she told me that I was supposed to bring out the bottles of Horizons for the guests and the special bottle of Cara for Genesis, I left and I saw a canister of pesticide near the kitchen. I asked Harper, why is that there?
What did you find out?
Well, she said it was to take care of pests like Genesis.
So what did you do after that conversation?
Well, after that, let me see. Let me try to remember. Oh, that's right. I was getting ready to work on the soup service. So we had the leek and pea puree. I discovered that my pea was missing a little chicken bouillon, which I learned in France. And I went outside in my car to go grab it.
What happened when you went outside?
Well, it was then that I noticed Harper Martini and Genesis Petrillo in the middle of a heated argument. And I overheard Genesis yell at Harper, "You think you know what's best for Casey, but you have no idea. How dare you try to break Casey's heart?"
Objection. Hearsay statements by Genesis Petrillo.
Response.
Yes, Your Honor. This is an exception to hearsay, Your Honor, under Rule 8031. This is, Your Honor, this is a present sense impression. As the witness previously stated, as he was walking out to his car, he saw this particular event occur, and so as he was witnessing it, this particular statement occurred, and this is a present sense impression, Your Honor.
Your Honor, may I respond under 8031?
Yes. Yes, you may.
8031 present sense impression is made by the declarant. The declarant in this case is Genesis Petrillo. So Genesis Petrillo would be the one who is having the present sense impression. However, this is plaintiff counsel is arguing that, in fact, Mr. Arnold is the one experiencing this present sense impression. That doesn't qualify under Rule 8031. This is hearsay and does not have an exception.
Response, Your Honor.
Yes, you may.
Your Honor, the Genesis Petrillo was also at that particular occasion, Your Honor, and so as she was witnessing this heated discussion, she made this particular statement, and she obviously witnessed her. She obviously heard her own statement. So, Your Honor, this is still a present sense impression, Your Honor.
Your Honor, may I respond?
I'll sustain your objection, counsel. Please move on.
Mr. Arnold, what happened after you went to your car?
Well, I grabbed my spice blend and I finished up my pea puree.
So what happened next?
So after that would be, after the dinner, it was the toast. So Harper told me later that evening, as she was about to give up and do her speech, that was my plan to start giving out the bottles of wine for the guests. Everyone was to receive a bottle of Horizon, while Genesis was to have that special bottle of Cara.
Mr. Arnold, to your knowledge, did anyone else receive the Cara wine?
No, nobody else received that bottle. It was only for Genesis. It was reiterated many times, even as Harper was giving her speech.
What did you do after the wines were given out?
Well, after that, I was around 10, I believe, so I packed up and I was getting ready to leave.
All right, so now let's talk about the day of the wedding. How did that day start out for you?
Well, on my way to work, I received a call from Blair. I think it was close to 10:30. He called me to let me know that Genesis had passed. Immediately, I was concerned because as a food service provider, you think it's your food. But I haven't heard of anyone else from the night of the wedding rehearsal dinner that was affected or anything else. So it would have to, I don't know. It wasn't me.
Mr. Mr. Arnold, to your knowledge, did people at the wedding rehearsal eat your food?
Of course, I'm the food service provider. They only ate my food. I mean, the salad was a hit.
And Mr. Arnold, to your knowledge, outside of Genesis, has anyone else gotten sick?
No, not from my knowledge.
No further questions, Your Honor.
Cross, Your Honor.
Just one moment. Let's wait to make sure we have okay from the scoring judges.
Yes, Your Honor.
Okay, 1 and 2. All right, please proceed, counsel.
Mr. Arnold, I want to clear up something that you mentioned on direct about the night that Genesis Petrillo died. That night you were in the kitchen, right?
Yes, I was in the kitchen.
And Harper Martini was also in the kitchen.
Yeah.
And there were a lot of wine bottles in the kitchen as well, right?
Yeah, there was a lot of Horizon for everyone else and Kara's for the Genesis.
Right, so it wasn't just that Cara wine bottle that you mentioned before.
I'm sorry. What?
It was Harper Martini and the Cara wine bottle in the kitchen, right?
I don't understand.
Mr. Arnold, Harper Martini wasn't alone with the Cara wine bottle.
Oh, yes, of course. No, the kitchen has a staff. Yes.
And you mentioned that there were pesticides in the kitchen?
Yes, I saw a canister of pesticide and let Harper know.
But Harper Martini wasn't actually holding that canister of pesticides, was she?
No, I just noticed it there and she took care of it. She threw it to the employees section.
Now, you don't know how long that canister of pesticides had been in the kitchen?
Well, I don't know. I mean, I just saw it and I saw it there.
You don't know if someone else besides Harper brought it into the kitchen?
I don't know if anyone else saw Harper bring. No, Harper, I don't know if she brought it. It was just there and I told Harper.
Now, you never saw Harper Martini poison that wine bottle with those pesticides, did you?
I never saw that, but I did think that clearing out the kitchen during their lunch service was especially weird to work on finalizing gifts.
Mr. Arnold, I'm not asking you to speculate as to what you thought was weird that Miss Martini did. I'm asking you if you ever saw Harper Martini poison that wine bottle, and you didn't, right?
Objection, Your Honor, to asked and answered.
May I respond, Your Honor? This witness hasn't answered my question.
I'll sustain the objection, or excuse me, I'll overrule the objection. Counsel, please answer yes or no and answer the defense's attorney's question directly, please.
Mr. Arnold, you never saw Harper Martini poison that bottle of Cara wine, did you?
No, I never saw that.
No further questions, Your Honor.
Excellent. Would plaintiff like to proceed with any redirect?
No, Your Honor. At this time, we just ask that Mr. Arnold be allowed to step down.
All right. Thank you very much, Mr. Arnold. You may be excused.
Thank you.
While the scoring judges jot down that last portion, would the plaintiff like to call its third witness?
Yes, Your Honor. The plaintiff calls Dr. Jimin Kwon to the stand.
All right. Dr. Kwon, thank you for being here. Always nice to be in company with other professionals. And you are under oath. Make sure that you answer the questions truthfully. Plaintiff, you may proceed.
Before we begin, Your Honor, we would like to ask for a brief time check.
Around 8:42.
We have the same.
Wonderful.
All right.
You may begin.
Please state your name for the court.
My name is Dr. Jimin Kwon.
Now, what do you do, Dr. Kwon?
Well, I'm the emergency physician at River Valley Hospital in Midlands.
Why are you here today? And
I happen to be the treating physician for Genesis Petrillo the morning of his death.
now, doctor, what, if any, education do you have?
So I first got my medical degree at UNC Chapel Hill, and then I went to get my residency at Emory's Department of Emergency Medicine, and I stayed there to complete a fellowship in medical toxicology in particular.
Now, doctor, what relevant medical experience do you have?
So I myself, I've been an ER physician since 2003. Although I treat all sorts of patients, I do specialize in toxicology. So when suspected poisoning cases ranging all the way from alcohol to homicide, are admitted, I'm the one that's usually assigned them.
Now, moving on to today's case, what, if any, information did you have?
So I first encountered Mr. Petrillo in the emergency room in the early morning hours. I was able to directly observe his symptoms, and I did complete a full medical examination.
Were all these materials sufficient for you to come to your conclusion?
Yeah, so this, along with the further tests that I ran, was sufficient for my medical analyses.
Now, doctor, moving on, what were your methods in examining today's victim?
Right, so I always treat my patients with the STAR method. The S stands for symptoms, the T stands for tests, the A stands for assessments, and the R stands for reassessments.
Now, doctor, is this method reliable?
Oh, you betcha. It's something that I always teach all of my first year students, and if I recall, the error rate is very low as well. I'd say around 2% maybe.
Doctor, did you reliably apply this method in today's case?
Most definitely I did. Same way that I always do in treating all of my patients.
Now, doctor, let's move on to your method, the S part of your method, the symptoms. What, if any, symptoms did you see?
Of course, so when Genesis was first admitted into the hospital, I noticed symptoms like vomiting, slurred speech, and even inability to walk.
Doctor, moving on to the T part of your method, the tests. What, if any, tests did you perform?
So I first did a blood test to check Genesis's BAC, or blood alcohol content. And furthermore, I did also order toxins analysis just as a precaution.
Doctor, moving on to the A part of your method, the assessment, what did you initially assess?
So initially, I did think it was alcohol poisoning.
Now, doctor, earlier you mentioned a toxins analysis, correct?
Yeah, I did.
Would you recognize a copy of the toxins analysis?
Most certainly, yes.
Your Honor, permission to screen share what has been previously marked and admitted into evidence as Exhibit 6.
Permission granted.
Dr. Kwan, what am I showing you?
Oh, this is the toxins analyses.
Is it a fair and accurate copy?
Yeah.
Has it been changed or altered in any way?
No.
Now, doctor, what, if anything, stands out to you about this toxin analysis?
So there's one thing that really stands out, and that's the presence of isofenphos in the patient's stomach contents.
Now, doctor, you mentioned earlier about your initial assessment. What do you mean by initial?
So upon further examination, I noticed that the patient was experiencing additional odd symptoms like muscle twitches, contracted pupils, and excessive tearing of the eyes. Furthermore, the patient also had a slowed heartbeat.
Now, doctor, moving on to the R part of your method, the reassessment, what can you tell us about the reassessment?
Right, so the new symptoms that I were noticing were not congruent with alcohol poisoning. So I suspected that the patient may have ingested something toxic, particularly an isofenphos organophosphate.
Doctor, can you tell us what an isofenphos organophosphate is?
Of course, it's a pesticide that's commonly used, especially around here in Midlands, to kill bugs, and they're pretty dangerous if mishandled.
Now, doctor, how can the patient come into contact with a pesticide?
There are multiple ways that one can come into contact with pesticides, but ultimately I concluded that the patient had ingested pesticides through either a contaminated food or a drink.
What, if anything, did you conclude about this contaminated food or drink?
So I tested the patient's stomach contents, and I found two things: wine and food. The food tested negative for pesticides, but only the wine tested positive.
What, if anything, helped you confirm your conclusion?
Well, there was a follow-up test on the wine bottle by the police, and that wine bottle also tested positive for pesticides.
Would you recognize a copy of the analysis of the wine bottle?
Yes, I would.
Your Honor, permission to screen share what has been pre-marked and admitted into evidence as Exhibit 10.
Yes, you may.
Doctor, what am I showing you?
This is that police testing on the wine bottle.
Has it been changed or altered in any way?
No.
Is it a fair and accurate copy?
Yeah, looks like it.
Doctor, could you elaborate on this test of the wine bottle?
Objection, Your Honor. This exhibit has not been. Oh, excuse me, I misread the title. I withdraw my objection.
Doctor, could you elaborate on the test of this wine bottle?
Of course, yes. So I found out that the police had found and taken a sample from inside of a bottle of Caro wine that the patient drank from, and that this laboratory analysis showed that there was pesticides inside of the wine bottle.
Doctor, what did you ultimately conclude?
I can say to a reasonable degree of scientific certainty that Mr. Petrillo ingested wine that was contaminated with an organophosphate pesticide, and that this contaminated wine gave him pesticide poisoning, causing his respiratory system to fail and ultimately resulting in his death.
No further questions, Your Honor. We pass the witness.
Thank you, counsel. Defense, would you like to proceed with cross-examination? Actually, wait, let's wait for the scoring judges. Just 1 minute.
Yes, Your Honor.
All right, wonderful. You may begin.
Good afternoon, Dr. Kwan.
Good afternoon.
I want to start by giving the jury some context about your background. You're on the board of Organic Solutions, aren't you?
Yes, that is correct.
So just to clarify, this is an organization that advocates against the use of chemical pesticide, right?
Yeah, I mean, this case is a prime example of what happens when pesticides are mishandled.
Doctor, you hope this case pushes legislators to ban chemical pesticide.
Objection, Your Honor. Improper opinion may be heard.
Yes, you may.
Your Honor, the opposing counsel has asked a question that elicits a response from the witness regarding the legislation of what's going to happen with legislation of organophosphate pesticides. That is an improper opinion, and it is also speculation.
May I respond, Your Honor?
Yes, you may.
That was not my question. My question was, you hope that this case will lead to the ban of pesticides. I'm asking him to testify if it's going to happen or not.
I'll overrule the objection. I agree. I don't believe that's what the questioning's designed to elicit a conclusion from. Please continue.
Yes, Your Honor.
Dr. Kwan, you hope that today's case pushes legislators to ban chemical pesticide.
Well, I guess hope is one way to put it, but we'll have to see if legislation does change.
Hope is the way you would put it, right, Doctor? You hope this case pushes legislators.
Yeah, that is a possibility in the outcome of today's case.
Okay. I want to talk more about the materials you were able to review. You didn't have an autopsy in today's case, isn't that correct?
I'm sorry, what was that? You cut out for a second.
Excuse me. Let me know if at any point my questions aren't clear. You didn't have an autopsy in today's case.
An autopsy? Oh no, just the tests and the analyses that I ran.
So you weren't able to review any autopsies when preparing your report?
I was a treating physician on the night that Mr. Petrillo entered the hospital. I had no need to perform an autopsy.
But the jury, right, doctor, I'm not asking if you performed one. I'm asking you if you had one and you weren't able to review one, correct?
No, that's not my responsibility as a treating physician. That's up to the coroner.
Okay, but the jury doesn't have confirmation about your conclusions from an official autopsy, right?
From an autopsy? No.
Okay, now I do want to talk about some of the tests you did run. You ran a test on blood, on the victim's blood?
The blood test? Yes, I did.
But this test couldn't tell you how much blood there was in Mr. Petrillo's system.
Are you asking how much blood in particular was in his body?
That wasn't my question, Dr. Kwan. My question was if the test can tell you what the amount is, and it can't.
The amount of blood in his body I'm confused by a question.
I'm sorry, let me clarify. The test you ran on the victim's blood cannot tell you how much pesticide there was in the blood?
Oh, pesticides. No, not. We don't get a quantitative value. We only get if there's indicators like a yes or a no.
Okay, and I want to bring up a test that you showed the jury in direct examination. You brought up Exhibit 10, isn't that right?
That was the, I believe, the police analyses, right?
Yes.
Yeah. Yes.
This time.
All right, what was your objection, counsel? Oh, asked to display the exhibit.
Yes, Your Honor.
Yes, you may.
I just want to note something in this test for the jury. Right here at the end, it says that there were only trace amounts of pesticide in the bottle. Isn't that correct?
Yeah, that's what the report says.
Okay, doctor. Now, you don't know how much pesticide there was in that bottle at the time the victim drank it, correct?
At the time that the victim drank it?
Yes.
No, we only got that report once the bottle was found later, so.
All right, doctor, you concluded the victim died because of pesticide poisoning.
Yeah, so respiratory failure due to pesticide poisoning, that's correct.
Doctor, you weren't able to come up to a conclusion about how that bottle got poisoned.
No, that's not my job. I simply treated Genesis in the hospital, medical checkups, examinations, tests.
That's right, doctor. Because of your scope, you can't conclude whether this was an accident, right?
Anything's on the table, sure. It could have been a possibility.
Objection, Your Honor.
And your objection is?
To, if I may take a moment to confer with co-counsel, Your Honor.
Okay.
Your Honor, the objection is to asking a legal conclusion. Your Honor, the attorney has asked what his scope is. The witness only knows that he knows about medical conclusions. Therefore, he cannot determine what his scope is in the realm of in the legal realm.
I'll overrule it because the question is not asking him to make a legal opinion or an opinion on whether there was negligence. It's that he's unable to, I believe. So I'll overrule the objection. Please continue, counsel.
You can't conclude if this was an accident. Isn't that correct?
That's correct. Anything's on the table right now.
No further questions at this time, Your Honor.
Would we like any redirect?
Yes, Your Honor. A brief redirect.
Okay, please continue.
Dr. Kwan, you were asked about an autopsy. Could you explain?
Yes, so as I've stated, I'm the chief emergency physician. So when people are entered into the hospital, I treat them, I run tests, analyses, as I've stated. But when it comes to the autopsy, that's up to the coroners. That's not something that's included in my line of work as a treating physician. Hence, an autopsy would have played no role in my report that I wrote for today's trial.
And Dr. Kwan, you're also asked about being on the board of an organophosphate pesticide advocacy group. Could you explain a little bit about that as well?
Yeah, so as I mentioned, this case, Mr. Petrillo clearly died with pesticides in his system, and pesticides were tested positive in the wine content in his stomach. And this is a clear example that pesticides entering the human body is simply so dangerous, even in minute amounts. I've done so much research and I have a huge background on toxicology and how organophosphate poisoning works, and I can confirm this.
And doctor, finally, you were asked about that you do not know if it was an accident, correct? You do not know if it was an accident. Based on that, your conclusion, could you re-elaborate on your conclusion?
Yeah, so as I've stated, I ultimately concluded that Mr. Petrillo died of pesticide poisoning, which is, from an accident standpoint, I'm not so sure about that.
Objection, Your Honor? That's an improper opinion. Like opposing counsel pointed out, he can't make these kinds of opinions outside the medical field. Testifying that pesticide poisoning, that he's not sure if that's intentional or an accident, that's inadmissible.
Your Honor, may I respond?
Yes, you may.
Your Honor, the witness is simply stating that he doesn't know if it is an accident or if it isn't an accident. We're trying to clarify for the court because opposing counsel has asked, he does not know if it is an accident. And per your prior ruling, because the witness is able to testify to that, the witness should be able to testify that he also doesn't know if it's not an accident.
Right. It's the same thing. In fact, it's asked and answered, but I'll overrule the objection. Just go ahead and proceed.
Now, Doctor, could you re-elaborate on your conclusion?
Yeah, so when it comes to Genesis dying of pesticide poisoning, whether it's an accident or not, I just don't know.
No further questions, Your Honor. We pass the witness.
All right. Thank you.
Thank you.
Thank you very much, Doctor. All right. Does the plaintiff have any further witnesses?
No, Your Honor. At this time, the plaintiff rests our case in chief. If defense counsel is fine with it, may we do we have time for a 5-minute recess?
Absolutely. So let's do 5 minutes. Everyone, please turn off your cameras. I've been told to make sure everyone's aware that it's still going to be recording. So make sure to keep your microphones off as well. See you in 5 minutes.
Yes, Your Honor.
All right, I believe that's 5 minutes. Defense, are you ready to call your, also scoring judges, are we ready to begin? All right, excellent. Defense, please call your first witness.
Yes, Your Honor. At this time, the defense calls Mr. Austin Lewis to the stand.
Good morning, Mr. Lewis. You are under oath. Please answer your questions truthfully, and you may proceed.
Good morning. Could you please introduce yourself to the jury?
Oh, my apologies. I was on mute. My name's Austin Lewis.
And what do you do for a living, Mr. Lewis?
Well, I'm a part owner, a full-time employee, and the #1 fan of Peony Estates. I'm the head winemaker over there, and so I oversee our harvesting, our growing, fermenting, bottling, and aging of our wines.
How are you qualified to oversee all of these important things?
Oh, well, I practically grew up on a winery. When I was younger, my mama was in charge of the old Cumberland's Farm winery. So everything that I know about winemaking came from her. She'd start every day by waking me up with a little Austin Carpe Venum, seize the wine. She was real talented.
So, Mr. Lewis, how are you related to today's case?
Well, my entire life is Peony Estates, honestly. I know the ins and the outs of winemaking there.
So let's talk some more about those ins and outs. Where is Peony Estates located?
Well, we're right up next to a swamp. It's called the Solo Swamp. So ever since day one, we've had a pest problem at Peony Estates.
Now, how do you address that pest problem at Peony Estates?
Well, you got to get rid of the pesky things somehow, and we used to try the organic solutions over at Peony Estates, but they were just too darn expensive and they honestly didn't work. So we had to move on to chemical pesticide. It was definitely a difficult switch, but it was necessary.
Now, you mentioned that you used chemical pesticides, right? Where do you spray them?
Well, at first we only sprayed the pesticide outside. We did it directly on the vines and then on the foundations on the outside of the buildings, but the pests were a big problem and they began popping up everywhere. So we started using pesticide inside too. You know, the wine cellar, the bottling room. Heck, I even thought about using them in the bathroom.
Mr. Lewis, I want to make something very clear for the jury. Did you spray pesticides in the same place that you store your wine at Peony Estates?
Yes, ma'am. You know, I say sometimes that it's either spray the pesticide or just let the bugs enjoy the wine for free. And we only take paying customers at Peony Estates, so had to get rid of them.
Now, Mr. Lewis, earlier you mentioned that you spray the vineyards. Is that where you grow your grapes for your wines?
Yes, ma'am. The vineyards is home to all our delicious grapes.
Well, now that we've established how pesticides are used at Peony Estates, I want to talk more about how winemaking works at a vineyard. Mr. Lewis, if I showed you a depiction of a vineyard, would you be able to better explain how winemaking works at your winery?
Sure thing.
Your Honor, permission to share a demonstrative?
You may, counsel.
Now, while we're waiting for the demonstrative to come up, can you explain how grapes are distributed at the vineyard?
Sure thing, ma'am. So at Peony Estates, we grow grapes on a sloped hill. It's similar to this one. We have some grapes on top, and these grapes are for our more expensive and fine wine. That's because they have a better soil. But we've got grapes at the bottom, and these grapes get too much water because of the slope. And so they're bigger and they're used for our more affordable wine.
Mr. Lewis, I know I keep talking about the vineyard, but you mentioned that you spray pesticides in the vineyard earlier. How does that work?
Right. So we start by spraying pesticides at the top of the slope, and you know that tends to run down the hill towards the bottom grapes, and the bottom is flat. So there's no drainage system, and the grapes can tend to get waterlogged where the pesticide pools. So we have to make sure to be extra careful with those grapes.
So just to clarify, Mr. Lewis, what do you mean that you have to be extra careful with those grapes?
Well, we make two different tiers of wine at Peony Estates. We make some with the top grapes and some with the bottom ones because, they're different. We got to make sure the wine at the bottom doesn't have too much pesticide in it because of the runoff down the hill. So I throw out about 20% of our grapes every single year.
Now that we've talked about the fact that there's two different tiers of wine at Peony Estates and how the winemaking process normally goes, let's talk about 2019 specifically. How long does it take for your wine to age at Peony Estates?
We aged wine for 1 year.
So what wine was made using the 2018 harvest?
We used the 2018 harvest to make the 2019 Carroll wine.
And back in the 2018 harvest, did you follow that process of throwing out 20% of those lower grapes?
No, ma'am, not personally. I actually went home for my mother's heavenly birthday on the weekend that we were supposed to be throwing them out. So I was not there for that.
So what did you do about that?
Well, I asked Harper Martini to get rid of those waterlogged grapes while I was gone.
And do you know if Miss Martini followed your instructions?
No, ma'am, I don't. I sure hope she did, because the last time that I talked to Harper about throwing out grapes, she said that I throw out too many. So I'm really not sure if Harper did throw them out.
Mr. Lewis, what happens to grapes at your winery that aren't thrown out?
Well, they get used in the production of the wine.
So if the grapes from that 2018 harvest weren't thrown out, would they be in the 2019 Carroll wine?
Yes, ma'am. And like I said, the pesticide pool's at the bottom, so that would be kind of dangerous. The
Objection, Your Honor.
The grape.
Your objection is?
Under Rule 403, inconsistent with the pleadings.
Inconsistent with the pleadings in which way?
Your Honor, may I make an offer of proof, specifically displaying the battery pretrial order?
Just go ahead and tell it to me.
Yes, Your Honor. In this battery pretrial order, both sides were specifically admonished from using evidence that specifically went towards a negligence argument. Your Honor, I believe that the specific argument going towards how the wine was improperly dealt with in regards to pesticides goes towards a negligence argument and has nothing to do with the battery claim in today's case, Your Honor.
Response, Your Honor.
Yes, you may.
Your Honor, actually, under the battery pretrial ruling number 1, it states that evidence of Peony Estates pesticide usage and/or storage may be admitted by either party if such evidence is relevant to other issues, such as intent and/or causation. This specific line of testimony goes towards establishing that causation, how the pesticide got into the 2019 Carroll wine that Genesis Petrillo drank. And because of that, it is admissible.
Counsel, I don't think that rebuts opposing counsel's point, because causation is shared among both elements of negligence and battery. And just to make sure that I have this clear, counsel, you are here in today, you are representing this winery, affirmatively trying to show that they committed negligence to avoid the battery claim. Is that your theory?
Your Honor, we're not trying to show that there was any specific type of negligence. We're just trying to show that Peony Estates could have been the reason why this wine was contaminated instead of Harper Martini. We're trying to establish that this death was an accident. Your Honor, if you would like, we could share the pretrial ruling number 1 to the screen.
May I respond, Your Honor?
Yeah, you may. You may.
Your Honor, this is going exactly towards a negligence argument. Your Honor, opposing counsel is arguing that the negligence of Peony Estates in regards to how they handle their wine is the reason for Genesis Petrillo's death, Your Honor. This goes directly against the battery pretrial order, Your Honor, and therefore should be inadmissible.
An accident is negligence. And I do see that this is a potentially potentially troublesome theory that you're trying to do here. If the rules of procedure state that you cannot try to use and rely on a negligence argument to avoid the battery claim, and that is an issue. However, we are already deep into this. All right, yeah, go ahead.
Oh, Your Honor. According to, as you can see, the pretrial ruling number 1, evidence of Peony Estates pesticide usage under storage may be admitted by either party if such evidence is relevant to other issues, such as causation. Moreover, you can see right before that, plaintiffs may not enter any evidence or testimony relating to negligence, the storage of pesticides. But right after that, it says that either party can admit any evidence about pesticide usage specifically. And that's exactly what we're doing in today's line of testimony.
I don't think either of those points definitively explain what the ruling should be on this, because again, the evidence can be, this is simply just which evidence can be admitted. And those are to prove elements, again, common to both, not intent. And this is a battery claim. This is the purpose why we're all here in court today. So that's perfectly relevant. Opposing counsel, plaintiff, please state again that rule saying that opposing counsel cannot rely on negligence.
Your Honor, it's right here in the summary judgment, Your Honor. The opposing counsel is trying to use how the storage, how the acquisition of the wine and how they used the pesticides in a negligent manner led towards the death of Genesis Petrillo, Your Honor. This goes directly against the pretrial order, Your Honor.
Well, this isn't a summary judgment. In your answer, defense, what is your stated theory?
Your Honor, we're simply asserting that Genesis Petrillo's death could have been an accident, and that Peony Estates mishandling pesticides could have been a reason why this death was an accident. Specifically, if you look at this pretrial ruling, it also explains intent and or causation. This pretrial ruling helps us establish the fact that Miss Martini did not intend to poison that wine, which is certainly relevant in today's case. By showing lines of testimony that support the fact that this wine could have been accidentally contaminated, we're showing that Harper Martini did not intentionally poison the wine.
Well, you're correct that negligence is a defense to battery. It obviously doesn't have intent. And we're already deep into this thing and we can't change course now. However, I think that your client may appreciate not being liable for another tort in this proceeding where there are alternate theories such as potentially not being liable in any way. But let's go ahead and proceed. You certainly can overcome the element of intent by trying to show negligence. So I'll overrule the objection and you may continue.
Yes, Your Honor. Now, Mr. Lewis, would it surprise you if the wine that was made from those bottom grapes is the one that Genesis Petrillo drank before he died?
Well, I know that he drank Cara wine, but I honestly don't know if he drank the cheap one from the bottom grapes or the other one, so I just can't be sure.
Thank you, Mr. Lewis. No further questions.
Okay, defense?
May I proceed, Your Honor?
Actually, let's get thumbs up from the scoring judge. Excellent. All right, you may proceed, defense.
Mr. Lewis, you're familiar with Harper Martini, correct?
Apologize, plaintiff. You may proceed. Sorry.
Oh, do you need me to stop, Your Honor?
No, not at all. Continue.
Mr. Lewis, you're familiar with Harper Martini, correct?
Yes, we've been friends for a good while now.
And you're also familiar with Casey Soto.
Yeah, Casey hangs out around the winery all the time.
And you also happen to know Genesis Petrillo, correct?
Yeah, sometimes Casey brought Genesis around.
You happen to see the relationship between Harper and Genesis, correct?
Not myself, no. Anything that I really knew about them two was more just what Harper would tell me.
So you had knowledge of the relationship, correct?
Yes, through Harper.
And based off of what you know that the relationship was contentious, correct?
Yeah, I tried to stay out of that. Really, I'm not really into the mother-in-law family drama type stuff, so I didn't really get involved.
I understand, Mr. Lewis. Now, Mr. Lewis, Harper told you that she did not like Genesis, correct?
That's correct.
In fact, Harper told you that she hated Genesis, correct?
Yeah, I guess she thought that Genesis was some type of bad influence.
All right. Mr. Lewis, yes or no, Harper told you that if she could push a button and make Genesis disappear, she would do it, correct?
Yeah, she did.
And to your knowledge, Harper wanted the wedding canceled, correct?
Yes, that's correct.
Now let's move on. To your knowledge, Harper was aware of how the pesticides were stored, correct?
That's correct. I trained all the employees, so everyone knew.
Harper was also aware of where the pesticides were stored, correct?
That's correct. Yes, sir.
Now, moving on to late 2018, an employee got sick, correct?
Yeah, so I believe that we had left out a glass of wine and some pesticide.
Okay. Redirecting you back to my question, yes or no, in 2018, an employee got sick, correct?
Yes, sir.
And yes or no, that employee got sick from pesticide poisoning, correct?
Right, like I was saying, there was a glass of wine left out, some pesticide got in it, so an employee ended up drinking it and did get sick.
So that's a yes to my question?
Yes, sir.
All right. So yes or no, that there was a glass of wine that was exposed, correct?
Right.
And yes or no, Harper Martini had knowledge of this incident, correct?
Yes, that's correct.
And yes or no, Harper Martini.
So Harper Martini having knowledge of this incident, that's speculation.
Any response?
Your Honor, I'm simply asking, based on the witness's rationally based perception, considering the fact that he has interacted with Harper Martini multiple times as he's an employee of Ms. Martini, this is simply his rationally based perception about whether or not Harper had knowledge of this incident, Your Honor.
Respond to
no need, counsel. I'll sustain your objection. Please continue.
Mr. Lewis, Harper told you that she knew about this incident, correct?
That's correct. That's actually how I learned about it.
Right. And Ms. Martini told you that she knew about the pesticides being in the wine, correct?
Right.
Objection to that, Your Honor, to asked and answered. The opposing counsel continues to ask the same line of questioning that has already been established by Mr. Lewis.
Response, Your Honor.
You may.
Your Honor, my first question was going about the general knowledge of this incident. My second question, if I may make an offer of proof, Your Honor, is going to the specifics of how pesticides interact with the wine and the defendant's knowledge of that interaction, Your Honor. So this is an entirely different line of questioning.
Yeah, I see the slight variation in it. I'll overrule, but please move on.
Yes, Your Honor. Mr. Lewis, Harper told you that she knew that the wine was difficult to smell, correct? The pesticides in the wine were difficult to see, correct?
To see, yeah, you can't really see pesticides in wine.
She also told you that pesticides could not be smelled, correct?
Correct.
Now, this employee almost died, correct?
Yeah, it sounded pretty dangerous.
Moving on, you are an employee of Peony Estates, correct?
Yes, sir, and part owner.
Right. You have a 10% stake in Peony Estates, correct?
That's correct.
Mr. Lewis, you are obviously aware that there is a trial involving Peony Estates, correct?
Yes.
You are aware that it's possible that Peony Estates could lose, correct?
Objection, Your Honor.
And the objection is?
Confusing the issues in today's case, Your Honor. This line of questioning goes towards establishing some kind of personal stake in today's case for Mr. Lewis. That's confusing the issues in today's case. Mr. Lewis isn't the defendant in today's case. That's Harper Martini. Mr. Lewis is simply just testifying on behalf of Peony Estates.
Response, Your Honor?
Yes, you may.
Your Honor, I completely agree with opposing counsel. This is going towards a personal stake with Mr. Lewis. In fact, this is the exact reason I'm asking the question, Your Honor. This goes directly towards the witness's bias towards his employer, Peony Estates, the fact that he has a 10% stake, Your Honor. So I could not agree more with opposing counsel.
If the objection is confusing the issue in that it's irrelevant, then I will for sure overrule the objection. It is probative. It's his credibility. So overruled.
The objection was not to the relevance of this line of testimony. It was to the fact that Mr. Lewis is not the defendant in today's case. Opposing counsel referred to him as the defendant, and they're questioning him like he is the defendant, which he is not today.
Is that true, plaintiff? Are you referring to Mr. Lewis as the defendant?
No, Your Honor. I was specifically asking Mr. Lewis about his 10% stake in Peony Estates, Your Honor. Obviously, the defendant is Harper Martini.
Okay, overruled.
Mr. Lewis, you have a 10% stake in Peony Estates, correct?
Right, I'm part owner, so I have a stake.
And you are aware that Peony Estates could lose this lawsuit, correct?
Well, is this lawsuit against Peony Estates?
Yes, specifically regarding Peony Estates, the lawsuit.
Well, I don't believe that Peony Estates is on trial here.
Your Honor, to confusing the issues, under Rule 403, the defendant is not Peony Estates. Mr. Lewis is simply just an employee of Peony Estates. He's testifying today, but he is not the defendant in today's case. The defendant in today's case is Harper Martini.
Response.
Your Honor, I could rephrase my question specifically talking about Harper Martini.
Right. We have to bear in mind, this is entity theory. So Peony Estates is an entity and shareholders own an interest in that entity. And while they themselves are testifying on the stand on their own behalf as witnesses, obviously you can't put a company on trial. But Peony Estates, the entity, technically is the defendant in this case. So I think all of this is very relevant. There's definitely not a conflict of or conflating issues here. So you may continue with this line of questioning. It's fine. Overruled.
Yes, Your Honor. Mr. Lewis, you are aware that Peony Estates could lose this lawsuit, correct?
Yes.
And you believe that if that were to happen, you would lose some money, correct?
I mean, I guess, but I'm very confident in my skills and what my mom has taught me, so I know I can.
So is that a yes to my question?
Yes, sir.
No further questions.
Any redirect?
No redirect, Your Honor. We just ask that Mr. Lewis be able to step down.
All right, Mr. Lewis, thank you very much. You may be excused. Okay.
Your Honor, time. If all judges are the judges ready for us to proceed?
Scoring judges, y'all ready to go? Outstanding. All right.
The defense calls Harper Martini to a stand. And Your Honor, sorry, you're on mute.
All right, Mr. Pineda, yeah, that's fine. Ms. Martini, you're under oath. You may begin at any time, Mr. Pineda.
Good afternoon, Ms. Martini. Can you please introduce yourself to a jury?
Hi, I'm Harper Martini.
Ms. Martini, I want to cut right to the chase. You're being accused of poisoning Genesis Petrillo. Did you poison him?
No. I love my daughter Casey, and she loved Genesis. I would never do anything to hurt her, let alone another person.
So I want to talk about your relationship with both of these individuals, your daughter and Mr. Petrillo. What was your relationship like with Casey, your daughter?
Well, me and Casey are super close. I'm a single mom, and I have been for all of Casey's life, so it's just been me and her. Every vacation, every birthday, every holiday. It's just me and my daughter.
And when did Mr. Petrillo come into your lives?
Well, when Casey was back in undergrad, she used to bring her friends over to the winery for holidays. She said it was because I was a cool mom, but pretty sure it was just because I had a shed of wine. Anyways, she brought Genesis one day to the winery. And the moment I saw him, I just knew that he was trouble. You know, moms know these things.
So, what was your relationship like with Mr. Petrillo?
Well, like I mentioned, I didn't really like him that much. I didn't want him to marry my daughter, but I tried to make amends. You know, he meant a lot to Casey, and so he meant a lot to me.
Were you able to make amends with Mr. Petrillo?
It felt impossible. I was trying to be civil and make him feel incorporated into the family. But then one night he went and he drunk called me. He told me that I would never see them again and that they were going to move to France after the wedding. He said I would never see any grandkids they had, or I would never see my daughter again. He even told me that I was going to die alone.
Ms. Martini, how did you react when Mr. Petrillo told you these things?
Well, I was really scared for my daughter. I mean, her fiance just called me to tell me that he was going to take her away from me forever and I would never see them again. So I knew that I had to do something. It was just so unlike Casey also to move across the world and
Objection, Your Honor. Speculation as to it was so unlike Casey.
May I respond, Your Honor?
You may.
Your Honor, Casey is this witness's daughter. She can testify to what she believes is consistent with her behavior that she's observed her whole life.
Response, Your Honor?
I'll overrule.
Yes, Your Honor.
Continue.
Ms. Martini, what were you saying about your daughter and what you expected from her?
I was saying that I would think it would be unlike her to move across the world and not even tell me. So I wanted to do something.
What did you do?
Well, I overreacted looking back on it. But I really thought that the relationship was unhealthy for Casey, and I was scared for her. So I decided to try and give Genesis money to leave Casey, just to even see if it would work.
How did that conversation go when you offered money?
Well, it wasn't much of a conversation. I just sent a note in an envelope with some cash to Genesis.
Would you recognize that note if I showed it to you?
I would.
Your Honor, permission to screen share Exhibit 24.
Yes, please do.
Ms. Martini, is this the note that you were referring to?
It is.
Is it a fair and accurate depiction of that note?
Yes.
Your Honor, at this time, the defense moves to enter Exhibit 24 into evidence.
Any objections?
None, Your Honor.
Okay, it's admitted.
Ms. Martini, can you explain to the jury why you wrote this and what you meant?
Objection under compound.
Break up the question into two questions, counsel.
Yes, Your Honor.
May I get a ruling?
Yes.
Oh, sustained.
Yes, Your Honor.
Ms. Martini, why did you write this note?
Well, when Genesis called me and threatened to take my daughter away from me, it really scared me. So I just wanted to see if he would leave Casey. So I wrote him the note offering him $300,000 to leave.
Okay. Ms. Martini, I expect you're going to be asked about this. Down here you say, otherwise I will take you out of the picture the hard way.
Objection, Your Honor. Speculation as to what the attorney expects to be asked about.
May I respond, Your Honor?
Yes, you may.
This is a direct examination of the defendant. I'm allowed to inoculate the evidence that she will be asked about.
I'll overrule the objection for sure. You may poison the wine well, as it were. So please continue.
Yes, Your Honor.
Down here you say, otherwise I will take you out of the picture the hard way. Can you explain to the jury why you said that?
Well, if Genesis wasn't going to take the money, then I was going to try to get Genesis help at a rehab facility. Genesis had a tendency to drink too much, too frequently.
Objection, Your Honor, calls for speculation. This witness is not an expert in wine drinking and how much someone should be drinking. That seems like a question that should be more for a doctor in toxicology and not for a lay witness winery owner.
May I respond?
Yes.
We're not asking the witness to give an expert opinion, and she did not give one. We're explaining her state of mind when she was writing this note and what she meant. So we're not offering that she drank too much to prove that she actually drank too much or to give that expert opinion, but she's explaining what she meant with this note.
Then, Your Honor, may I ask for a limiting instruction that that testimony is just for that and that this witness is not actually specifying whether or not Genesis actually did drink that much?
Yes, I'll overrule the objection. Mr. Pineda, rephrase your question, make sure that the witness is aware to answer specifically to her lay understanding of Mr. Petrio's drinking habits.
Ms. Martini, what did you observe that made you write this note and explain that rehab thing that you meant?
Well, I can't even count how many times I've seen Genesis get so drunk he passes out. And one time he even urged Casey to drink as much as him, and she ended up in the hospital. So I thought that he could use some help, and that's what I meant by that.
So just to be very clear, did you mean you were going to kill Genesis?
No, of course not.
Okay, Ms. Martini. Now I want to talk a little bit more about you. Can you tell the jury what you do and how you're involved in your company?
Objection or compound again?
Goodness, the whole spacebar thing doesn't work for me half the time. I'll overrule. I think they're related enough.
Yes, Your Honor.
And actually, Ms. Martini, before we get into your company, I do have one more question about that. How did Mr. Petrio respond when you gave him this note?
Well, he took the money.
So what did that mean for you?
Well, I assumed that he was going to leave Casey because he took the money. I didn't think there was going to be a wedding.
Okay, Ms. Martini. Now, can you tell us how you're involved in your company?
Yes, I'm the owner of Peony Estates. So I take care of planning events, hosting people at our bed and breakfast, trying to determine what wine that we should plant, or excuse me, what grapes we should plant to make our wine for the next year, things like that.
And are you involved with the process of spraying pesticide?
No, I'm not really involved with the harvesting process. That's Austin Lewis's job. He's our head harvester. I'm mainly in charge of the business side of Peony Estates.
So were you here earlier for the testimony of Mr. Lewis?
I was, yes.
And you saw him describe the vineyard process. Are you involved in that at all?
No, I'm not. The only thing that I really tend to with the harvesting process is tasting the wine before we sell it.
So, Ms. Martini, you tasted the wine you gave to Mr. Petrio, is that what you're saying?
No, like Mr. Lewis explained, there's two different types of wine, our higher tier wine and our lower tier wine. I tasted wine from the top of the hill because it's our more refined wine, and that was the wine we were planning on selling. The lower quality wine is of the bottle that I gave to Genesis.
So just to be clear, did you give Mr. Petrio Cara wine from the top or the bottom?
From the bottom. The wine from the top is more expensive, and in 2019, Peony Estates was struggling a bit financially, so we needed to make as much revenue as possible.
So if you didn't taste the wine at the bottom, did you have any way of knowing if it was poisoned?
Well, I didn't taste it myself, but I trust my employees to make sure my wine is safe, or I wouldn't give it to Genesis or anyone in that matter.
Okay, Ms. Martini, I understand that you trust your employees, but I just want to get this very clear for the jury. Because you didn't taste it, was there any way for you to know if it was poisoned?
Not directly, no. But again, I wouldn't give anyone wine that I thought was unsafe.
Okay, Ms. Martini, now I want to address some of the allegations that have been made against you during trial today. Were you ever violent towards Mr. Petrio?
No, of course not. Never.
Were you ever in a kitchen filling a bottle with pesticide, Ms. Martini?
No, I was in the kitchen with Sam Arnold putting ribbons on the bottles to give out to guests. That's all.
Okay, Miss Martini, did you try to poison Mr. Petrillo at any point?
No. Like I said, Genesis meant a lot to my daughter, and my daughter means a lot to me. I would never do anything to hurt him.
No further questions at this time, Your Honor.
All right. Wait a moment. Make sure the scoring judges are ready. Wonderful. All right. Mr. Babineau, you may begin.
Yes, Your Honor. Miss Martini, I'd like to talk a little bit about your business in Genesis. The first time you took Genesis to your winery was in 2015, right?
That sounds about right, yes.
And the first thing he did when he got there was insult your business, didn't he?
Yes, that's true.
He said that that Rapid River Valley wasn't hip enough for the artsy-fartsy Peony Estates, didn't he?
Yep, that's true.
And he's insulted your business on other occasions, hasn't he?
He has.
In fact, Miss Martini, it was hard for you to view Genesis as anything other than a threat to your business. Isn't that right?
Yeah, sometimes whenever he was at the winery, he would go up to people that were eating and tell them that our food was rotten or crazy things like that.
Exactly, Miss Martini. He'd go to your guests and tell them they were eating rehydrated space food, didn't he?
Yeah, he definitely had an odd sense of humor, to say the least.
Miss Martini, I didn't ask you if it was a joke. I asked you if that's what he said. That's a yes, right?
Yeah, that's what he said.
And Miss Martini, I'd like to move on to May 2019. Genesis sent you a voicemail, didn't he?
Yes, he did.
And you recognize that voicemail if I were to show it to you again?
I would.
You're under permission to screen share what's been pre-admitted as Exhibit 8.
You may.
Okay.
I said you may.
Yes. Now, Genesis told you that he was going to Paris, what, didn't he?
1 second. I just need to read the voicemail real quick. Yes, he did. He said that they were going to go to Paris after their wedding.
And he said he was taking your daughter with him?
He did.
He told you that you were going to die alone in that sad winery, didn't he?
Yes.
And so later that month, you can take this exhibit down. So later that same month, you sent Genesis a note, as you mentioned on direct examination, right?
I did. I was afraid for my daughter.
And you'd recognize that note if I were to show it to you again in court today.
I would.
You're under permission to tender to republish Exhibit 24.
Yes. Permission granted.
I'll go ahead and ask about it while that screen sharing is being put up. You told Genesis to take $300,000 and leave Casey, didn't you?
I did.
And Miss Martini, you gave him until June 7th to make his decision, right?
I did.
And correct me if I'm wrong here, June 7th was the day you gave Genesis that car of wine, isn't that right?
June 7th was the day of the rehearsal dinner. I gave him until the day of the rehearsal dinner, but that night was when Genesis died, so I decided not to do anything.
Miss Martini, let me redirect you back to my question. The day that you gave Genesis that car of wine was June 7th, yes or no?
Yes, the day of the rehearsal dinner.
Now, you can take this down. Now, let's talk about that car of wine. You'd agree with me that you've had car of wine before, haven't you?
Yes, I tasted the top tier wine before we bottled it.
And Miss Martini, after you tasted that car of wine, you didn't get sick, did you?
No, I didn't.
In fact, you bottled that car of wine because you thought it was ready, didn't you?
Exactly. The top tier wine tasted ready to be bottled, aged, and sold.
Miss Martini, I'm not asking you about the top tier wine. I'm asking you about the wine that you tasted. You bottled it after you thought it was ready, didn't you?
I'm sorry. That is the wine I tasted. Yes, that's true.
And you gave Genesis a bottled bottle of car of wine, didn't you?
Yes.
Okay, Miss Martini, now let's talk about what you do know. You have access to the Peony Estates pesticides, right?
I know where they are. That's it.
And you know how to use Peony Estates pesticides, right?
Vaguely.
Ms. Martini, let's go back to that. Let's go back to that day of June 7th. After you gave Genesis that wine at 2 in the morning the next day, you went into Genesis's room, didn't you?
I'm sorry, I'm confused. You're talking about the night of June 7th?
The night of June 7th, early June 8th.
Okay.
You did go into Genesis's room, right?
Yes, I did. I went to go check on him. He had a lot to drink that night.
And you took that car of wine out of his room, didn't you?
Yes, he left it on the floor and it made a little wine stain on the carpet, so I decided to clean it up.
Miss Martini, I didn't ask you about cleaning it up. You took that wine out of his room, didn't you?
Well, yeah, I went to go throw it away.
You tore off the label, right?
Yes, I did. And
then you threw it in the trash.
That's correct.
And Miss Martini, later that day, you learned that Genesis Petrillo died?
Yes, the morning of June 8th, I did.
And Miss Martini, let's be honest, a part of you is relieved that Genesis Petrillo is gone, isn't it?
Yes, I'm happy that he's not going to take my daughter away anymore. It really scared me when he threatened to do that.
Miss Martini, redirecting you back to my question, that's a yes, you're relieved that Genesis is gone, aren't you?
Yes, I'm relieved because of my daughter.
I pass the witness, Your Honor.
Any redirect examination?
Yes, Your Honor.
All right, you may begin.
Ms. Martini, I just want to clear this up. Did you taste the wine that you gave to the victim?
No, I didn't drink the bottle of wine that I gave to Genesis.
No further questions.
Any read cross?
Your Honor, may I inquire as to how much time we have remaining?
Sure. Timekeepers, could you please let us know how much time we have?
Yes, Your Honor, we have 5:45 remaining.
Okay.
Brief recross, Your Honor.
Okay. Try to limit it to the scope of Mr. Pineda's redirect.
Yes, Your Honor. So, Miss Martini, you gave Genesis car wine, right?
Yes, I gave him the cheap version of the car wine bottle. That is correct.
I didn't ask about the version of the car wine. You gave her car, right?
Yes, that's the blend, but there's two different versions of the wine.
And you tried car wine before you gave it to Genesis, didn't you?
Yes, I tried the top tier wine, the wine that we were selling.
Miss Martini, you were deposed, right?
I was, yes.
And nowhere in that deposition did you mention 2 tiers of car wine, did you?
Nobody asked me about the tiers of our wine. I'm sorry.
Miss Martini, I'm not asking about what you were asked. I'm asking, you never mentioned it in your deposition, right?
Your Honor, I asked the opposing counsel let the witness answer the question. She's trying to impeach her and asking her if she mentioned in the deposition. The witness explained that it's a deposition. She wasn't asked this question. And it's fair for the jury to hear this testimony.
Response, Your Honor?
All right.
I asked the witness a yes or no question that she never mentioned 2 types of wine in her deposition. She can safely say that she didn't mention that, or she can say that she can. The witness talking about what she was asked is going outside the scope of my question. That can be taken up on redirect if necessary.
We don't do redirect, but I'm going to overrule the objection. Make sure that where this is going is relevant, and remember that witnesses are able to make reasonable inferences from the facts stated in their affidavits, just not inventions.
Yes, Your Honor. So, Ms. Martini, again, I'll ask you, yes or no, you never mentioned 2 types of car wine in your deposition, did you?
No, again, I didn't mention it because I was never asked.
Your Honor, at this time, we pass the witness.
Okay. Ms. Martini, you may be excused. Thank you very much. All right. Does the defense have any other witnesses?
Yes, Your Honor. Defense calls Dr. Cannon to the stand.
Okay. Dr. Cannon, you are under oath. Scoring judges, are you ready to proceed? Then there you go. All right. Let's begin.
Good afternoon. Could you introduce yourself to the jury?
Good afternoon. I'm Dr. Richard Cannon.
What do you do for a living?
Well, I'm an associate consultant for Gardner Consulting Incorporated. But that's not how I started my career as a medical professional. I was actually the chief toxicologist at Massachusetts General Hospital up in Boston. And then I decided to move to Midlands to take a faculty position at the local med school. After that is when I decided to become a medical consultant over at Gardner.
And where did you get your education to do that?
Well, I got my bachelor's in chemistry from the Ohio State University, go Buckeyes. And I got my MD with an emphasis in toxicology from Harvard Med.
Dr. Cannon, how are you related to today's case?
Well, I was hired by the defense to analyze the report of Dr. Kwan. Dr. Kwan was the treating physician of Mr. Petrillo on the night before and the morning of his death.
How did you go about analyzing Dr. Kwan's report?
Well, typically in my work as a consultant, we're very limited in resources to just documents. I'm not actually in front of the patient. And so I analyzed the documents that were provided to me by Dr. Kwan. I got to review his report and any of the materials that he had. And I used the method of comparative analysis to follow along his report and write down whenever anything's unaccounted for. I could go through all of the steps that Dr. Kwan is supposed to take, and I note when something vital is missing from his report.
How reliable is this method?
Well, as reliable as it can be, I'd say. It's pretty much the gold standard in medical consulting, at least. Comparative analysis is a form of a peer review. And, well, it's frequently used to test the strength of reports and the scientific method itself.
Did you reliably apply this method to your conclusions in your analysis in today's case?
I did.
So what were Dr. Kwan's conclusions?
Well, Dr. Kwan concluded that the victim died from pesticide poisoning.
Did you agree with Dr. Kwan's conclusions?
Objection, Your Honor. Improper opinion, may I be heard?
Yes, you may be heard.
Your Honor, pursuant to Rule 702, 702A states that the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact and issue. Your Honor, the witness has not testified to being an expert in the field of specifically pesticide poisoning. And if I may take the witness on a brief voir dire, I can show that the witness does not have any specialized knowledge to help assess the facts of the case.
May I respond?
You may.
Your Honor, this witness stated that they used to be the chief toxicologist at the hospital in Massachusetts. They've worked with pesticide and poisoning before. This witness has laid all 702 foundation and can testify as an expert. I ask that we proceed with the witness.
Very interesting. I do want to hear what Ms. Kim believes she can rule out from his testimony. Let's engage in a very, very brief voir dire. And at that point, we can rule on the objection.
Yes, Your Honor.
So,
Dr. Cannon, you practice medicine. Oh, my pardon, Your Honor.
I apologize. I just said, please proceed.
Yes, Your Honor. Dr. Cannon, have you practiced medicine?
I have.
And you went to medical school, didn't you?
Yes, I did.
And after that, you engaged in some extra training, didn't you?
Sure, yeah.
And that extra training is called a residency, isn't it?
Well, yes, you have to go through a residency.
And after that, did you go through any other special training?
Well, I was the chief toxicologist, not just anyone.
Dr. Cannon.
I'm explaining that I received special training to be the chief toxicologist. So yes, I did.
But Dr. Cannon, did you agree that a fellowship is a specialized training?
That's one type of specialized training. Being a chief is above fellows, obviously. So I receive even more.
Now, Dr. Cannon, redirecting you back to my question, a fellowship is a specialized training, correct?
Yes.
And you did not do a fellowship, did you?
No, I did more training by becoming the chief toxicologist.
Now, Dr. Cannon, you published articles, haven't you?
I have.
You've published, in fact, 50 articles, haven't you?
I believe so. I lost count after a while.
And Dr. Cannon, which one of these articles are based on isofenfos?
I'm sorry. I don't believe there's any specifically in isofenfas. That is one type of specific
And
pesticide.
which of your articles is regarding organophosphate pesticides?
Again, organophosphate is one specific type, so I don't have any articles specifically about organophosphate.
So redirecting you back to my question, that's a no. You do not have any articles regarding organophosphate pesticides.
Not specifically organophosphate, that's one type, but I have written about pesticides and toxicology in general.
Your Honor,
like you said, over 50 papers.
Your Honor, the use today, I re-raised my objection to an improper opinion as today's testimony is regarding an organophosphate pesticide. The witness has testified that he has not written about organophosphate pesticides. He did not do a fellowship in toxicology. Therefore, Your Honor, the witness still has insufficient knowledge. Therefore, we should limit the scope to the witness to only be about medical knowledge, but not specifically organophosphate pesticides.
Ms. Worth, how do you respond?
Yes, Your Honor. Your Honor, this witness just testified that they were the chief toxicologist at one of the biggest hospitals in the nation, in Massachusetts. They clearly have specialized knowledge. Your Honor, there aren't only two ways to get specialized knowledge, as Ms. Kim is trying to imply, through a fellowship or through writing papers. I ask that I'm able to proceed with this witness as we've laid the 702 foundation and strike the voir dire that Ms. Kim just made.
Your Honor, may I respond to those grounds?
No, Ms. Kim, I'm going to overrule your objection. I don't believe that that was able to, I believe that Ms. Worth has laid sufficient foundation to show that he is a toxicologist. And although he doesn't have a specialization in the exact organophosphate that was in the wine, he still has standing to be able to speak on such a toxin. And as for the move to strike, I will move to strike. We will do that. And for timekeeping's sake, I believe I saw the timekeeper bring up, and that was part of the plaintiff's time, and that's correct. It should be part of the plaintiff's time. So I'm going to overrule the objection. Ms. Worth, you may proceed.
Yes, Your Honor.
Dr. Cannon, did you agree with Dr. Kwan's conclusions?
Well, I agreed that the victim died from pesticide poisoning. That's what Dr. Kwan broadly concluded. But I do believe there are some gaps in that conclusion by Dr. Kwan.
When you explained this to me earlier, you used a visual aid. Do you think that would help the jury now?
Sure.
Your Honor, may I put up a copy of Dr. Cannon's visual aid?
Yes, you may.
Just give us, oh, there it is. Dr. Cannon, could you explain what you're seeing here?
I can. Right here, I summarize Dr. Kwan's conclusion in a visual format. Dr. Kwan concluded that the pesticide somehow went into a bottle of wine and that the victim, Mr. Petrillo, died after consuming it. The gaps in the evidence come in when we try to apply this conclusion to how the victim died.
What was the first gap?
Well, as you can see in the next slide, Dr. Kwan ran a test on the victim's blood. And that test did determine that there was pesticide in that blood, but it didn't determine how much there was.
So why does that matter?
Well, there's pesticides in almost everything we eat. There are safe levels, of course. Don't worry about that. So naturally, we're all going to have some pesticide in our system. If someone just ate fruit recently, that's higher than the majority of foods. They might test positive for an amount of pesticide. This test can't tell us whether it was a small trace amount of pesticide or a high suspicious amount that the victim had in her blood.
Was there a second gap?
Yes, another test was also run on the bottle of wine, again for pesticide. But this bottle was actually found in a dumpster next to a pesticide canister. We don't know how much pesticide would have been in the bottle before it was in the trash can. When the victim was actually drinking from the bottle, we don't know if that bottle had residue from pesticide or if it was an actual suspicious amount.
So now that we know about the gaps, how do they apply to Dr. Kwan's conclusions?
Well, Dr. Kwan concluded that the victim was poisoned with pesticide. And that theory is consistent with many different ways that that bottle could have been contaminated. There are a lot of possibilities, and I won't list all of them. But for example, Dr. Kwan's conclusions are consistent with anything from the wine being just near pesticide, somehow getting contaminated, to the grapes having pesticide on them even before becoming wine, or with someone intentionally poisoning the bottle. Like I said, those are just some of the possibilities. They're really endless.
Objection, Your Honor. To improper opinion, may I be heard?
Okay.
Your Honor, if I may direct the court's attention to case law, particularly Kane's Software Company versus Mars Investigation. In 1998, the Midland Supreme Court has ruled that Midlands does not permit parties to use their experts as weapons in a trial by ambush or unfair surprise. Your Honor, these conclusions are nowhere in Dr. Cannon's report, and therefore it is improper as it is it is trial by ambush.
May I respond, Your Honor?
Yes, you may.
Your Honor, a couple of things here. First, Dr. Kwan opened the door when Dr. Kwan testified that it could either be an accident or not, and when Ms. Kim asked Dr. Kwan specifically about that. I'm also able to ask Dr. Cannon about Dr. Kwan's conclusions, and Dr. Kwan did talk about this on their direct. Furthermore, Your Honor, this is not a conclusion by Dr. Cannon, so this case law doesn't apply at all. Dr. Cannon is merely talking about where Dr. Kwan's conclusions begin and where they end. In fact, he's talking about the absence of conclusion that can be made outside of Dr. Kwan's conclusions. This case law does not apply.
Response to that, Your Honor?
Yes.
Your Honor, Dr. Cannon is currently then not testifying to things that are in his report. He's still drawing conclusions from Dr. Kwan's report. Therefore, these are still conclusions that should have been included in his report. Therefore, Kane's software still applies to this testimony.
As to whether or not Mr. Cannon's drawing conclusions, I agree with you, Ms. Kim. He is drawing conclusions. However, as to your objection that this is unfair surprise, citing the case law that you cited, I disagree. I believe that Mr. Cannon was brought here to raise doubt in the conclusions of Dr. Kwan. And so far as I've been able to ascertain, that's exactly what he's done. So could you, yes?
Yes, Your Honor. We were just saying that these facts are outside of the report of Dr. Cannon. Therefore, it is unfair. It is trial by ambush because we were not given notice of this. Dr. Cannon had up until today to amend his report as he see fit, and he did not continue to do so. Therefore, this is still trial by ambush, Your Honor.
Which specific fact are you saying he hasn't stated in his affidavit? He's ambushing.
We're talking about the conclusions that he's drawing, about the conclusions that pesticides may have been put into the wine, were next to the wine, or that they were sprayed onto the wine, and that's how it got into the bottle. These are conclusions that he is drawing, that there's other ways that these are conclusively inside of the bottles. Therefore, that it's still a conclusion that was not included in his report. His report lists other possibilities, but these specific possibilities are not in the report. Therefore, it is still trial by ambush, Your Honor.
Ms. Worth? Yes.
Your Honor, Dr. Kwan already testified to this exact thing that Ms. Kim's talking about now, so this is within the scope of Dr. Cannon's testimony right now. Furthermore, Your Honor, this sounds like something that Ms. Kim can cross on with Dr. Cannon, but I am able to ask Dr. Cannon about these kinds of things. May I proceed?
Ms. Kim was correct in saying, I mean, just because he brings it up in his own testimony, it doesn't change the fact that these are new facts that weren't in his affidavit, and he did have a chance to amend. So I'm going to sustain the objection, but limited. Dr. Cannon, do not testify specifically as to your theory of how it may have gotten into wine. That addresses a completely separate matter of winemaking, and you're here to testify solely on Dr. Kwan's report. So I'll sustain in that limited sense and overrule in any other limitations that Ms. Kim is seeking to limit. So please continue, Ms. Worth.
Your Honor, may we ask that this demonstrative which shows these conclusions to be taken down per your ruling?
Yes. Please
yes,
take this slide. If there are other slides you need to use, then you may use those. Ms. Worth, you can continue.
Dr. Cannon, what kind of conclusions can you draw in today's case?
Well, only that the victim was poisoned with pesticides, really. Dr. Kwan's conclusions don't tell us how the poison entered your system.
Thank you, Dr. Cannon. No further questions, Your Honor.
Right. Judges, are we ready to proceed with cross-examination? All right. Ms. Kim, you may begin.
Yes, Your Honor. Now, Dr. Cannon, let's begin. Pesticides were inside of Genesis Petrillo's system, correct?
That's right.
And pesticides were found in the bottle that Genesis Petrillo had drinking from, correct?
Yes, trace amounts.
And let's move on, Dr. Cannon. So at the wedding rehearsal, no one else was sick. To your knowledge, no one else was sick, correct?
No, based on the report that I read and the affidavit of the witness I read, I don't know if there was any more. No, not to my knowledge.
So that's a no to my question. No one else was sick.
Not to my knowledge.
And the victim received a bottle of wine, correct?
I believe so. I did read that in the affidavit of an eyewitness.
And this bottle came from the defendant, correct?
I don't know.
Dr. Cannon, you reviewed the affidavit of Angel Rodriguez, correct?
That's right.
And you, in the, and Angel Rodriguez, excuse me, and Dr. Cannon, Angel Rodriguez, you read the affidavit of Angel Rodriguez, and it stated that the defendant had given the wine, correct?
I believe that the defendant gave a wine to an employee, and that employee gave it to the victim. Yes.
Okay. Dr. Cannon, after this, the victim consumed the wine, correct?
I believe so.
And after this, the victim got sick, correct?
Yes, that's why she went to, I apologize, went to the emergency room.
And Dr. Cannon, only the victim got sick, correct?
Again, I don't have knowledge of every single person that attended. I don't. But just based on my knowledge, Mr. Petrillo is the only one that I know.
Dr. Cannon, pesticides were in the stomach, correct?
Yes. Actually,
and
wine.
That is
Wine was
explained.
found. Oh, I apologize.
And that is explained. The presence of pesticides is explained by ingesting a pesticide, correct?
That's one way, yes.
And the victim passed away, didn't he?
He did.
And he passed away from respiratory failure, didn't he?
Yes, the cause of death was that pesticide poisoning led to that respiratory failure.
And to your knowledge, the defendant had pesticides, correct?
I believe there was wine found in her stomach that had trace amounts of pesticides within it.
Dr. Cannon, I'm not asking about the victim. I'm asking if the defendant had control of pesticides.
I apologize. I misunderstood the question. I don't know if the defendant had control of the pesticides.
Dr. Cannon, the defendant produced this wine, correct?
I believe she was the owner of the winery that produced this wine.
Time.
Dr. Cannon, redirecting you back to my question. Was that an objection?
No, that's time.
Okay. No further questions, Honor. We pass the witness.
Any redirect any redirect, Ms. Worth?
No redirect, Your Honor. May Dr. Cannon step down?
Yes, he may. Thank you, Dr. Cannon.
Thank you, Your Honor.
All right. So let's go ahead and take one final 5-minute break, and then we'll resume for closing arguments. Thank you very much.
Yes, Your Honor.
All right, scoring judges, are we ready to move on to closing arguments?
Yep.
All right, I think that's both of y'all. Good. All right, will the plaintiff reserve any time for rebuttal?
Yes, Your Honor. After my closing argument's completed, may I save however much time I have left over for rebuttal?
I'll limit it to 2 minutes. So that, and everyone, please turn your view onto speaker view, and you may begin at any time you're ready.
Yes, Your Honor. Your Honor, Ms. Worth, members of the jury, may it please the court. Members of the jury, I want you to think of the happiest day of your lives. Maybe it was the day that you locked eyes with your first love. Maybe it was the day that you looked into your child's eyes. Or maybe it was the day of your wedding. I want you to think about the emotions that you felt that day. And I want you to think about what it would be like had you never got to experience that because of someone else's plan to ruin it. Members of the jury, that's exactly what happened in today's case. June 8th, 2019 was supposed to be the day that Genesis Petrillo and Casey Soto were getting married. But instead of Genesis Petrillo walking down that aisle, exchanging his vows, saying his I do's, you heard today that Genesis was in a hospital bed, throwing up, dying of pesticide poisoning. Members of the jury, that's because the defendant the night prior did her plan to poison Petrillo. She took a canister of pesticides. She took a wine bottle. She evacuated the kitchen. And she put those pesticides into that wine bottle and gave it to Genesis Petrillo. And that's why we've sued the defendant for civil battery. And with that, we had to prove to you 3 elements. First, we had to prove that this was an act of the defendant. Second, we had to prove that that act came with an intent to harm. And third, and finally, we had to prove that the plaintiff, or in this case, the victim, suffered harm. And today, we've proven those things. We had to prove them to you by a preponderance of the evidence, which is big legal jargon that really means that we have to prove that our case was more likely than not. Members of the jury, today is not some law and order murder case. We didn't have to prove anything beyond any doubts. We simply had to prove that it was more likely than not that the defendant battered Genesis Petrillo, and we have met that burden today. First, we had to prove to you that there was an act, and for that, you heard testimony of that. You heard from the defendant herself that that car of wine was okay when she drank it. She didn't get sick. Members of the jury, she tried and tell you that there were 2 different types of car of wine, but she never mentioned that any time before today in court. That's because, members of the jury, it's not true. She knows that she tried that car of wine, that it was fine on its own. That the only thing that made it to where Miss Martini could drink it and be fine and Genesis drink it and die was the fact that an act had to be done, and you heard exactly what that act was. 2 witnesses at 2 different times placed the defendant with pesticides near that car of wine. Both of those witnesses at different times asked Miss Martini, "What are you doing with that car of wine?" And both of those times, Miss Martini said the exact same thing, that it was for pests like Genesis Petrillo. Then we had to prove that there was an intent for that act. To prove that, you heard from the defendant herself. Genesis Petrillo constantly demeaned Miss Martini's business. Genesis Petrillo went around telling people that the defendant's food was rehydrated space food, that the city wasn't hip enough for the Peony Estates. Members of the jury, you combine those things with what you read in that voicemail. Genesis Petrillo told Miss Martini he was taking her daughter, going out of the country, and that she was going to die alone at that sad winery. So how did the defendant respond to that? Well, you saw her intent in this letter. She said, "Take this $300,000, leave my daughter, or I will take you out of the picture the hard way. You have until June 7th to make your choice." Now, Genesis gave that letter back to Miss Martini. He didn't keep it. So to Genesis Petrillo, to Miss Martini, they made their decision. Genesis chose to be taken out of the hard way. And that's exactly what Miss Martini did. She went into that kitchen, she grabbed the pesticide, she grabbed that wine bottle, she mixed the two together, then gave it to Genesis that night. And third, we had to prove that there was harm done to the victim. And for that, you heard from both experts in today's case. Both experts testified that Mr. Petrillo, that Mr. Petrillo died of pesticide poisoning. You heard from our treating physician that he was in pain that night, that he experienced symptoms like slowed heartbeat, that he died of pesticide poisoning, members of the jury, and that proves that he suffered a harm. Members of the jury, we ask that you evaluate all the evidence you heard today, that you consider the facts, consider the testimony, consider the exhibits that you saw, and that you listen to which testimony is more likely. Is it more likely that the case theory that a judge already threw out, that they were careless, is it more likely than not that that judge was wrong? Or is it more likely than not that Miss Martini did actually poison Genesis Petrillo? You heard her words. You heard how she hated Genesis, members of the jury. So we ask you to evaluate this evidence, and when you deliberate, you're given this jury charge form that to all three of those questions, did she commit an act? Was there intent? And was the plaintiff damaged? That you circle yes to all three of those. That you find justice and find the defendant liable. Thank you.
Thank you, counsel. All right. Is the defense ready to proceed with its closing argument?
Yes, Your Honor.
All right, you may begin.
May it please the court. Not every story has a villain. Mr. Babineau just told you a great story. Now I have to say, it sounds a bit familiar, doesn't it? I will give the plaintiff some credit. They did swap out an evil stepmother with an evil mother-in-law, and a poisoned apple with a poisoned bottle of wine. But other than that, members of the jury, the plaintiff's story sounds just like fairy tales we heard when we were children. We all know that fairy tales and reality are two different things. So what is reality in today's case? The reality is that Harper Martini is a hardworking, loving mother who built a winery from the ground up while raising her daughter as a single mother. The reality is that Harper Martini didn't get along with her daughter's fiance because she was protective of her daughter. She wanted her daughter to finish college and marry someone who treated her right. The reality is that Harper Martini is a mother, not a murderer. But on June 7th of 2019, Genesis Petrillo drank a bottle of contaminated wine. He died. How does a terrible, tragic accident like that happen? Well, today the head winemaker at Peony Estates told you about their winemaking process. He told you how Peony Estates grows their grapes on a hill, how Peony Estates sprays chemical pesticides on their grapes, and how those pesticides can run off down to the bottom of the hill and contaminate the grapes there. He told you that Peony Estates often throws out the grapes at the bottom of the hill. But then he told you that in 2018, that didn't happen. Those grapes were mistakenly used to create the Cara bottle of wine that the victim drank the night that he died. That's reality. It was an accident. But the plaintiff has twisted reality into a fairy tale and created a villain out of Harper Martini to fit their story. But if the plaintiff wants you to believe this story, if they want you to walk out of the courtroom today and find Harper Martini liable for the death of another human being, they have to do more than a couple bad quotes and a poor relationship. They have to prove three things. One, that Harper Martini put pesticides in the wine that Genesis Petrillo drank. Two, that Harper Martini intentionally put pesticides in that wine, knowing that Genesis Petrillo would be harmed. And three, that as a result of that intentional action, Genesis Petrillo died. That's their burden today, to prove to you all three of those things by a preponderance of the evidence. That means that the plaintiff's story has to be more likely than any other alternative combined. And that's their burden. Never does that burden leave the plaintiff and fall on the defense. Now, what did the plaintiff bring you today to satisfy that burden? Did they bring you security footage of Harper Martini poisoning that wine? Did they bring you eyewitness testimony of the incident? Did they bring you forensic evidence of Harper Martini's fingerprints on the wine bottle or on the pesticides? No. They didn't bring that to you today because that evidence doesn't exist. Now, members of the jury, take a step back and think about what the plaintiff is asking you to believe. That on the night of a wedding rehearsal, when guests are arriving, family members are arriving, when people are getting food, preparing drinks, getting plates, Harper Martini takes a bottle of wine, walks into the kitchen, uncorks the wine, pours some wine out, pours some pesticides back in, recorks the wine, and in the middle of a toast, in front of everyone at the wedding party, she takes that murder weapon, she walks over to Genesis, and she hands it to him for everyone to see. That's the plaintiff's story. That's what they're asking you to believe, but their story doesn't end there. They're not asking you to believe that Harper Martini did this in the heat of the moment. They're saying that she planned this. You heard them in opening and closing. They said that Harper Martini planned to poison Genesis Petrillo. Sounds like the opening of a fairy tale, but it's not. It's the opening of their case. And then after, in the plaintiff's story, after Miss Martini makes this plan, she doesn't just keep it to herself, no. She goes around and tells people about it. And not just one confidant, she tells two people. And in the plaintiff's story, Harper Martini goes to the best friend of the victim, the person that she's about to kill, and she tells him that she's going to kill Genesis. And then right after that, she goes to the cook, and she tells the cook that she's going to kill Genesis. And then right after that, she goes up on stage and she does just that. Members of the jury, that's the plaintiff's story because they made up that quote. They realized they didn't have enough evidence, so they came up with that quote and then they got sloppy and had Harper Martini walking around the wedding rehearsal telling everyone that she was going to kill Genesis. That's their story today. Even both experts can't tell you whether this was an accident or intentional, because the scientific evidence points both ways. And we're not asking you to speculate as to what the scientific evidence means. We're asking you to believe it. Believe that scientific evidence. And what we do know about this case is that the grapes at the bottom of the hill were sitting in pools of chemical pesticides, and that those grapes were mistakenly used to create the very wine that the victim drank the night that he died. That's what we know. Members of the jury, not every story has a villain. Now, while we sympathize with Mr. Petrillo's family, we ask you to make a decision in this case. Now, the plaintiff wants to take this terrible, terrible tragedy and tear a family apart because of it. But at the end of the day, the decision's in your hands. Find Harper Martini not liable. Thank you.
Thank you very much. Plaintiff, would you like to begin with your rebuttal?
Yes, Your Honor. May I proceed?
Yes, you may.
Your Honor, Ms. Worth, members of the jury, may it please the court. Now, we absolutely agree with Ms. Worth's statement that that this case isn't a fairy tale, that not every case has a major villain. Members of the jury, we're not saying Ms. Martini was a villain. We didn't have to prove that. We are saying that she's a mother who saw her son-in-law as a threat to her business and saw that she was running out of time before her daughter would leave her forever and go to Paris. And so she acted and she poisoned Mr. Petrillo based off that. Members of the jury, opposing counsel talked about the burden, but if it's as simple as this, Your Honor, or members of the jury, if you hear our story and believe that our story is more credible than what they brought, then we've met our burden. It's not proving beyond any question, not proving beyond all doubt, members of the jury. An opposing counsel said that we claimed that we made up a line with two of our witnesses, but members of the jury, if you heard any evidence of making anything up today, it was their defendant and their expert. Both of them decided that what's in their statements, what they gave to the court prior to trial, was not sufficient. So they recognized they had to add things, that they had to make things up, not our witnesses. Members of the jury, we ask that you evaluate the evidence and evaluate the testimony that you heard, that you keep an open mind and that you keep a mind centered on justice, that you find justice for Genesis Petrillo against the person who poisoned him, and that you find the defendant liable. Thank you.
Thank you, counsel. All right, so that concludes our closing arguments for this case. What we're now going to do is we're going to begin the submission of the ballots. I ask that everyone please stay on, and judges, as soon as you're finished with your scoring, just let me know and we can begin with a brief comment and feedback section. So thank you all very much, and we'll be with you in just a moment. All right, so both of the judges have told me that they have submitted their ballots. Everyone, please go ahead and put on your cameras and take a deep breath. Whew. Wow. Firstly, congratulations. That was stellar. Really incredible advocacy from both sides. I was on the edge of my seat, and at no point was I ever bored. Really fierce back and forth on some objections. But yeah, so let's go ahead and take a moment for question and answer or comments, and I'll let the other judges start, and I'll finish it off. So Joe or Andrew?
Yeah, I just want to confirm, are we good to know what school they are? Do we have to wait for Elliot or someone from the tournament?
I think we can now at this point. What school are y'all in? Schools.
Plaintiff, we're UT Dallas.
Okay. Yeah. Welcome. And defense?
We're from UT Austin.
Oh man. So the UT crew.
Yeah, really. Texas representing.
That's what we like to see.
Yeah, that was not like a bloodbath in a good way. That was probably the closest round I've ever judged. So yeah, I'll introduce myself. I'm Joe Previty, I did Baylor mock trial. I was there for undergrad for 3 years. Recently graduated and currently working at a law firm right now. But yeah, this was a really good round, guys, and especially to be, I guess, dealing with the medium you're dealing with right now, having to do it through Xamta, like this was really good. So it was tough to do comments, and like the scores were very close. Like I've got them up on my other screen right now, and it was so close. I think the attorneys were absolutely stellar. I think the objection battles and thinking on your feet was second to few, if any. I think the overall knowledge of the rules was pretty good. I got a little confused at times when you guys might make an objection, like confusing the issues. Asher can correct me if I'm wrong, but if that's the right objection to make, then roll with it. If that's what your coach says, like make it. Odds are you guys can just hang your hat on like a 403 and be like, hey, like there's no reason to be discussing this. And even if it's relevant, it's just going to prejudice or confuse the jury anyway. That was one thing. In my time at Baylor, I was a witness to the extent of 1 or 2 awards. So a lot of my harsher comments are on the witness side of things, but I think the witnesses overall were pretty impressive. The thing that I always stressed, especially for lay witnesses, was consistency and confusion. And I heard a couple times the witnesses literally said, I'm confused. What are you talking about? And yeah, like you're at court for the first time probably in your whole life. So like, why should you know what the opposing counsel is trying to ask you? And if they're going to ask something that isn't strictly true, you're going to be like, well, no. And if they get all mad because you didn't answer their poorly worded or vaguely worded question, well, that's on them. You're not going to look bad, at least to someone like me who kind of like knows what you're expected to do. The other thing, I guess, for the witnesses, as far as people who like to play dress up and cosplay the witnesses, do bear in mind that this is what your character would wear if they had to go to court. So if I'm a construction worker and I have to go to court, I'm probably still going to put on, I don't know, t-shirt and jeans, even if I'm working that day. And if I'm a chef, if you want to wear the whole chef outfit, wear it. But I think you have to address it. Otherwise, it just looks a little cheesy. Be like, sorry, I'm wearing this. I just got off a 14-hour shift, like doing something like we had to cater 800 people or something like that. Similar to Dr. Kwan, you wore a stethoscope around your neck. I don't think you anticipated anyone to go into cardiac arrest during the proceeding, much less be able to attend to them over Zoom. So again, I think a brief explanation of like, hey, like I know I'm wearing this, and just to kind of like decrease not like a silliness factor, but to make it seem more real, like there's an actual reason you're wearing it besides saying, hi, I'm Doctor Who, but otherwise it was great. I thought people picked and chose their battles pretty well, especially on cross. I think there were not many yes but answers, or at least whenever they were used, they were cleverly and smartly used. But yeah, overall, fantastic job. And then I have other comments and like that are more specific.
I think that y'all have another round at 2, right? So Andrew.
Yeah, I'm cutting it there. So I have more specific comments in there. It should be helpful. Most of them are more harsh than nice, but I feel like that's more helpful than just saying good job.
Sure.
I've just got a few quick things, so I'll keep it short. I thought everyone did a nice job. If you're going to be on cross-examination, a little bit about me. I'm a 3L at Baylor Law School. I've done 7 moot court competitions for Baylor, and I'm on Baylor's mock trial team. If you're going to make if you're going to say to a witness, back to my question, or is that a yes or a no, really make sure that they didn't answer your question and that they didn't say yes or no. Because there were a couple of times where the witness, said no or not to my knowledge, which is a no. But you'd say, what, answer my question, yes or no. And they did. And it's not necessarily a bad thing, but if you're thinking about it in terms of credibility to the jury, you might come off as bullying the witness instead of trying to get to the truth, which is the point of the cross-examination. If you're going to have an objection, make sure that it's a real objection, that it's an accurate objection. If you get a ruling that confuses you, or that you think, oh boy, that was the wrong ruling, don't let it show on your face, because everybody in every case is going to get a ruling that they don't think they should have gotten. And also know when to stop fighting the objection. If you've said the right grounds, if the judge rules against you then on either party, or if the judge rules in your favor, as long as you stated the grounds, you preserved your error for appeal. And at that point, you're just losing the battle in front of the jury. So that's kind of what I had. I thought that everyone's directs went pretty smooth. Make sure that you're varying up the question format. I think, Mr. Babineau, I know that you're really trying to avoid a leading objection, so you're what if anything a lot. So just watch out for that. I don't think it was bad, but be careful because someone might get distracted by it. Other than that, that's all I have. I know you guys, I've got another round to judge it too, and I know you guys are busy, so thank you.
I had one more brief thing. The expert, I think it was Dr. Kwan. You said your error rate was 2%, right?
Yes, I did say that.
Yeah, that's awful. 2% is awful. Like you want a 2% error rate if you're measuring like how people like chocolate pudding in high school. Like yours needs to be thousandths of a percent error rate. So either say it and then you're going to raise a lot of eyebrows, or just don't talk about error rate.
Thank you.
Very, very minor thing though, but I'm an engineer, so I have to.
That's good. I wanted to talk just a couple things. First, I love the themes. I think that both teams clearly had theming. The plan to poison Petrillo, I love the alliteration. That's great. And then the fairy tale stories, that's a fine theme. So I'm glad that y'all raised it on opening. You tried to weave it in through the questioning of the witnesses, and so that's great. I also want to talk a minute about the theory of the defense, and this is personal, and I want you to listen to your coaches and follow what they feel. However, I think that there's a fine argument to be made that he died of alcohol poisoning without having to jeopardize the other cause of action of negligence that is supposedly, bifurcated. And also, I don't believe that bifurcation was mentioned during the housekeeping matters. So that may, if you're going to stick with the negligence thing, you may want to make it fairly clear up front. I mean, if you can get your client, absolved of both causes of action, for sure. Obviously, the intentional tort, there's already a whole lot of things you can knock out. It's hard to prove intent to kill someone. And I think that the doctor wrote, or the medical consultant raised excellent testimony about, how unlikely the causation was, how it could have been alcohol poisoning. So there was really great lines of questioning. Obviously, it's not judged on the merits. This is mock trial. But if you are going to do something like that, be prepared if there's going to be a weird objection battle like what happened at the beginning of the defense's case in chief.
Asher, can I ask a quick question?
Sure, please.
And it's because I don't know if it's appropriate. Someone tell me if it's not. Is Peony Estates a defendant? The pretrial order says that they were dismissed.
Yeah, Peony Estates is Harper Martini.
Yeah.
The defendant is just Harper? Okay, I was confused about that. And if that's the case, because I know Asher, that was a significant fight, in the middle of it. Make that crystal clear, because, if they're not a defendant, then absolutely say that. That was one thing that, because you guys have lived with this problem. I've never been to a competition where a judge knew the problem better than the people in the room. So, when you're trying to get the judge to do something for you, you've got to make sure that they know exactly why they need to.
Also, I want to just quickly say, I think that Andrew nailed it with objections. Just make sure you don't just yell objection and have the judge have to ask, and it is. And then finally, kind of nitpick, for those who dressed up, I kind of like that. I think that's a really subjective thing. So if you're kind of on the fence, listen to your coaches. I thought the witnesses were awesome. You guys were so fun. And I was just glued to the screen the whole time because y'all were engaging. So that is everything. And unless y'all have any questions specifically for us, I think that'll be it.
Thank you so much for judging.
Thank you for your time.
Thank
Welcome.
you.
Best of luck, guys. You guys are going to go far, I know.
Thank you.
Yeah.
Thank you.